Live stream audio check 1 2. It's now 10 to 1. The inquiry is resumed. Looks like everybody's here who needs to be here. So only one small point. I'm repatriated with my note of housekeeping, and I'm happy to say I covered all the things I wanted to. So that's a relief. Unless there's anything that needs to be picked up now, can we move on to the final witness, please, Mr. Boyle?
So thank you. Mr. Marsh, as you can see, is in position. Mr. Marsh has a summary. He has a proof and appendices, which in my version are bound together, and he has separately a rebuttal. So if you have the statement of common ground with the authority, so the main statement of common ground, as we've been calling it, and if you could also have access to the core documents, I'm going to principally look at A, which is the A1, I think it is, which is the core strategy, A2, which is the DM document. And then there are, I think, 4 of the appeal decisions, which are all in the core docs. I'll give you the references as we turn to them, apart from, I think, Farley Farm, which you have separately. So, Mr. Marsh, are you all present and correct?
Yes, thank you.
Thank you very much. Let me introduce you to the inquiry. As with other witnesses, for the benefit of those listening in, I'm going to ask you to read some parts of your summary, but principally we'll be indulging in questions and answers. So, your main proof indicates you're Chris Marsh, is that correct?
That's correct.
You hold a Bachelor of Honours, a first indeed, Bachelor of Honours, and Master's Merit in Town and Country Planning at the University of the West of England. You've been a chartered member of the Royal Town Planning Institute since 2014. You tell us you've practiced in both local government and the private sector, have over 10 years' experience advising primarily on development management matters, including for house builders at all scales. You tell us a little bit about your previous employment, and you came to Pegasus in 2020. You're familiar with the appeal sites, having shadowed your colleague Mr. Coombs, who we know he's sitting behind me, in running the outline application to client, ultimately directly overseeing its final stages of determination in autumn of 2021. You're conversant with the planning and other disciplinary matters relevant to the scheme which you there set out, and then we have your statement of truth. Is that correct?
That is correct, yes.
Thank you very much. Section 2 deals with the scope and also then the structure of your evidence. And 2.4, we see you relying, as would be expected, on the various experts across their different disciplines that the inspector has proofs from.
Correct. Yes.
Thank you very much indeed. Thank you. I can take you away from your main proof for a moment, please. Don't put it too far away, and ask you to take up your summary proof. Do you have that?
I have that, thank you.
And 1.6, I think, is where we can start. If you just start reading from there, please.
1.6. The main appeal site is situated adjacent to the settlement of Wrington in a location which is compliant in principle with the Operative Development Plan Policy, brackets, CS32, close bracket, locationally sustainable and accessible. These matters are agreed with the Council and the latter examined in the evidence of Mr. Jones.
And then just read on.
1.7. My evidence demonstrates the proposal's overall compliance with the substantive elements of policy CS32, which is supportive of residential development at all sizes outside of settlement boundaries at service villages. 1.8. The conflict arising in respect of CS32 relates solely to the procedural element of the policy, which in the circumstances explained in my evidence must be given no more than limited weight, brackets, per the decision at Cox's Green, close brackets, in the planning balance. 1.9. Paragraph 11D of the framework is engaged owing mutually to the Council's deficient housing land supply and the unreliability of the evidence underpinning what are now, by extension, out-of-date policies for the restriction of housing. 1.10. In respect of heritage, the appellant's evidence indicates the degree of less than substantial harm to the setting of the Grade 1 Church of All Saints is very limited, and to the setting of the Wrington Conservation Area non-existent. Additionally, the proposals will independently deliver modest heritage benefits. 1.11. Weighing these considerations appropriately in the balancing exercise prescribed at paragraph 202 of the framework, the public benefits of the development outweigh any harm, and thus the balance is concluded in the proposal's favour. Section 66(1) is duly satisfied, and the tilted balance remains engaged, as there is no clear reason for refusal under paragraph 11d, numeral 1. 1.12. The appellant's landscape evidence examines the impacts of the development, finding a low degree of localised harm that weighs against the proposals in the final planning balance. It is agreed between the main parties that the proposals would not affect a, quote, valued landscape, and that subject to mitigation, identified harm will be minimised, and thus satisfy the terms of policy DM10, thus ensuring policy compliance in this respect. 1.13. The footway link subject of Appeal B is agreed between the appellant and counsel, while my evidence has demonstrated why and how a suitably worded condition would provide an appropriate mechanism for its timely delivery. 1.14. The appeal proposals represent sustainable development and will deliver much-needed market and affordable housing at a time of local and national undersupply. Further public benefits, including provision of public open space, play, ecological enhancement, sustainable drainage, and both short and long-term gains to the local economy. 1.15. The delivery of housing commands substantial weight in favour of the proposals, with a timely delivery schedule that will provide real homes to real people who will, in turn, integrate with the community at Wrington and contribute to the social and economic sustainability of the settlement. 1.16. Wider economic benefits to the local and surrounding area include direct and indirect construction employment at a time when activity across large parts of Somerset is constrained by nutrient neutrality issues, together with the increased household spending power associated with attracting working-age new residents to the area. 1.17. Environmental credentials are fundamental to the appeal proposals, with significant on-site gains in habitats and biodiversity, strategic landscaping and open space commitments reflected in the Building with Nature accreditation obtained for the scheme. The reinstatement of historic hedgerow and water meadows, as well as new public views of the church to be created, are further environmental benefits of the development. 1.18. Considered in the context of paragraph 11d, numeral 2 of the framework and the tilted balance, granting permission in respect to the appeal proposals would not give rise to any adverse impacts that would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole. Conversely, in my view, the benefits materially exceed any identified harms. 1.19. Accordingly, my evidence concludes that the proposals represent sustainable development and that the appeal should be allowed an outline planning permission granted, subject to conditions and Section 106 legal agreement.
Thank you very much, Mr. Marsh. You can put the summary away now, please, and take up the statement of common ground.
I have that, thank you.
And if you go to section 1, page 1, in paragraph 1.7, we see the reasons for refusal helpfully set out there. And for reasons already rehearsed in the evidence, we can expunge the reference to the Wrington Conservation Area in reason 1.
I do apologise,
Are you
Mr.
there?
Boyle. I've picked up the statement of common ground for transport in lieu of the correct one. Sorry, please do
Main
bear with
planning
me.
proof. When you get there, page 1, 1.7.
I had every faith in my own indexing. Yes, I have that now, thank you.
Got it? Reason 1, heritage. I say for reasons already explored, we can expunge the reference to the Wrington Conservation Area.
Correct.
And although it's expressed as harm to setting, the relevant experts, of course, familiar with the test, it's the contribution of the setting to the significance of the heritage asset we're interested in.
That's my understanding, yes.
And in addition to policy CS5, policy DM4 has been added in for our consideration.
Yes.
Yeah, we'll come to that in a moment. And we know that the agreed position in terms of harm is, first of all, less than substantial. Say we're in paragraph 202 of the MPPF.
Yes.
And at the lowermost end of that scale, or the scale within that less than substantial category.
Correct, yes.
That's helpful. Thank you very much. Reason 2, then, we can see the allegation is proposed development by reason its location in an area of landscape high sensitivity, prominent location, scale in excess that's supported by CS32, hierarchical approach to settlements, would substantially alter an area of attractive open countryside to an urbanised area prominent in some localised views. This represents a form of development that would be out of keeping with the overall character of the village and its landscape setting. How would you characterise that reason, please, Mr. Marsh?
Well, I would characterise it bluntly as a landscape reason for refusal, in the context of which the relevance of scale in relation to CS32 is purely that seemingly it is as a function of that scale that the development would, quote, substantially alter an area of attractive open countryside and so on.
Thank you very much. Now, you heard Mr. Reynolds' evidence, do you recall, that out of the reference to hierarchical approach, he drew a different point, which was to do with the sustainability of the settlement for 61 dwellings.
Yes, of course.
If we go to the section called Matters in Dispute, which is section 7 of the Statement of Common Ground,
I have that, thank you.
do we there find any support for the proposition that the Council objects to the site in sustainability terms as being in some way insufficiently provided with services and facilities for additional 61 dwellings?
We don't, no, as far as I can see.
Thank you very much indeed. And if we go back to matters not in dispute, do you have that?
I do, yes.
Paragraph 6.6, where we see the words, "It is agreed that Wrington is a sustainable settlement and the site is locationally appropriate in terms of policy CS32, subject to appropriate conditions and obligations." To what extent do we there see an allegation that it's Wrington's sustainable settlement, but not for 61?
I don't see any such allegation. I would say that that paragraph encapsulates exactly that point, that it is a sustainable location.
Thank you very much. And then, do you have the core strategy to hand?
I do, yes.
And you'll find CS 32 is on page 130 of the document. Do you have that?
Just getting to it now. I have that now, thank you.
Grateful. And you see it's subject to 7 criteria, and then there is the proviso at the end about sites outside settlement boundaries in excess of 25 dwellings.
Yes.
So that, thank you very much. Now, do you recall, Mr. Reynolds' evidence that of the 7 criteria, he found that 1 and 4 were failed by reference to the heritage and landscape impacts, reasons 1 and 2?
Yes.
Didn't allege any other failures of the criteria.
No, that's my recollection.
And then he drew attention, obviously, to the exceedance of the 25, which should be brought by neighbourhood plan or local plans.
Yes.
Yeah? Okay. Can you just help me with this then, please? In the light of his purported sustainability objection, do you see reason 3, not reason 3, bullet 3,
I do, yes.
will not cause significant adverse impact on services and infrastructure, and the local infrastructure is sufficient to accommodate the demands of the development? Yeah?
Yes.
To what extent do the authority lead evidence that that criterion is breached by this proposal?
Well, they haven't advanced that position, to my knowledge, to date.
Thank you very much. And in the context, therefore, that there isn't significant adverse impacts alleged, or indeed insufficiency of local infrastructure to accommodate demands development, your view, please, as to whether or not CS32, as a matter of principle, prevents development of 60 as opposed to 25 coming forward?
I don't consider it does as a matter of principle, no.
Thank you. Thank you very much. I'm going to come back to CS32 for other purposes in a moment, so don't put that too far away. Would you mind taking up your main proof now, just to finish this point off? You have a section called Sustainability that starts at paragraph 321. It's on page 4 of your main proof.
I have that, thank you.
You want that? And if we just record what it says there, 321, Wrington has primary school, nursery, post office, convenience store, public houses, pharmacists, veterinary practice, memorial hall, sports and social club, places of worship, secondary and post-16 education is provided at Churchill Academy and sixth form. Then you reference bus stops and their locations and timings, the highway network, the settlements of Langford and Congsbury located within 10 and 15-minute cycle ride, regular rail services, Bristol and Western-super-Mare accessible from Yatton, 10-minute drive, and then dedicated connectivity by cycle route along the Strawberry Line, etc. And then you reference that wheel, which is coloured yellow, one green, and one red. Yeah.
Yes.
What is that wheel, and what was it used for?
So the wheel is something that's produced for each of the settlements in order to assess their sustainability by reference to a number of criteria, and it uses a kind of traffic light system to ascribe a level of performance being kind of good, bad, or in between. The in-betweens being essentially good enough, is my understanding.
Thank you very much. And you say of the 22 settlements assessed, Wrington came 9th in the hierarchy. And to what extent do you understand the authority to be doubting the correct characterization of Wrington as a service village for the purpose of CS 32?
Well, I don't believe there to be any case advanced that it doesn't that assessment doesn't carry through to the current consideration.
Thank you very much indeed. And we can see well connected, well served, thriving, well built and designed, active, inclusive, well run and fair for everyone. But the R, environmentally sensitive, that's the red notation. You have a text over the page to tell us what that concerned itself with. 327.
Yes.
There's no active community transition sustainability group. That's within the community, presumably, within the village.
Yes, I see that as a kind of community and governance point.
Yeah, to what extent is that a planning objection to a scheme for 61 houses coming forward?
I don't consider it appropriate to apply it to such a proposal.
There's no local recycling scheme, ditto?
Ditto, yes.
And then the next three, best most versatile land, fluvial flooding, and wildlife sites nearby. First of all, the first two are concerned. To what extent do they apply to the area proposed for development before the inspector?
In respect of the first criterion there, the BMV land, the inspector will be aware that obviously there is a report demonstrating that is grade 4 and thus two clicks away from being BMV land, so that isn't relevant to the proposal before us. In terms of fluvial flooding, that's obviously been subject of Mr. Stoodley's evidence, and in terms of the developable area, it will not bear on any of those identified areas. Finally, in terms of protected ecology, again, the site's been subject of detailed assessment, which is obviously accepted by the local planning authority, and I believe also now the Rule 6 party, and therefore isn't a shortcoming of the proposals.
Thank you very much. In fact, in terms of how the site itself performs for ecological matters, what's the biodiversity net gain balance?
The biodiversity net gain figures are very good for the site, and I think we need to bear in mind that those take a conservative position, not taking account of any additional value that, for example, additional woodland planting in that southern ecological area would deliver, and I can dig out the exact figures from my rebuttal, as there is a correction that I should draw attention to, a correction to paragraph 9.130 of my original proof, just to correct those figures, which would be correctly 30.68 net gain in respect of habitat units and 198.48% in respect of hedgerow units within the built envelope of the development.
Thank you very much. And so with that in mind, your view, please, as to whether the settlement of Wrington is a suitable and sustainable location for the growth of the proposed development.
In my view, it is a suitable and sustainable location, yes.
Thank you very much. You heard the evidence of Mr. Jones in terms of accessibility.
I did, yes.
In terms of the location of the site for accessing the services and facilities of this sustainable settlement. What's your view?
Pardon, could you repeat that?
Certainly. In terms of accessibility of the proposed site, for accessing the services and facilities within the settlement, what is your view?
Well, my view is that the accessibility of local services is perfectly adequate by a range of means, with various options for modes and indeed routes of travel. Also that in respect of the few services that are not provided locally, there are further options for those to be accessed in nearby settlements, and having regard certainly to paragraph 79 of the framework, that's a completely appropriate approach for this type of settlement.
Thank you very much. And consequently, even if there were a reason for refusal framed in the manner of Mr. Reynolds' first issue, do you remember how he put it?
Yes.
Your view, please, as to whether that's made out on the evidence.
I don't believe that it is on the evidence before us now.
Thank you very much. Okay. Right, I'm going to look at policy matters. I'm going to start with what I'll call sort of DC, Development Control, or DM, Development Management Policies first, and then we'll look at the strategic suite of policies in terms of locational appropriateness for development. So I'm going to start with the heritage ones raised in the reason for refusal 1, CS5, and if you go back to CD A.1, you'll find CS5 on page 40.
I have it, thank you.
We covered this with the witnesses for the authority, but could I just confirm your view? A test of, I'm so sorry, historic environments, the second half, CS5 covers both.
Yes.
So we'll come back to it, CS5, for landscape in a moment. But a test for will conserve, do you have that?
Yes.
To what extent does that recognise the distinction made in the MPPF between the concept of substantial and lesser substantial impact on significance of the heritage asset, and then the relevant tests that flow therefrom?
It doesn't differentiate or expound in those respects.
And so to be consistent with the MPPF, what test should we be applying? The one in CS5 or the one in paragraph 202 of the MPPF?
Depending on the degree of harm, it should be 201 or 202 in the framework.
Thank you very much indeed. Thank you. Let's go to DM4, which is in the next core document. It's CD A.2, and DM4 is page 15. Do you have that?
Bear with me. Let me just get to Yes, I have it, thank you.
Got it, page 15, DM4, first paragraph. Development will be expected to preserve and, where appropriate, enhance character ... listed building and its setting. Yeah,
yes.
Same point to you. To what extent does that reflect the distinction drawn by the NPPF and the test separately there set out?
Likewise, it doesn't differentiate.
Thank you. And if a scheme with parties are agreed that there is an impact, albeit at the lowermost end of the scale, if a scheme is subsequently judged to then pass the 202 test, to what extent is that then national policy compliant in heritage terms?
Well, once it's satisfied the paragraph 202 test, it would be compliant with national policy.
And what's the consequence of that for the duty under section 66(1) of the Listed Buildings Act?
Per Mordew, then that duty would have been discharged in conducting that exercise.
Thank you very much. Similar point then with the landscape objection. That's reason 2. And we have to go back again to CS5. It's the first part of CS5 now.
Yes, I have it.
The character, distinctiveness, diversity, and quality of landscape and townscape will be protected and enhanced. ... Yeah?
Yes.
Again, to what extent does that reflect the division by national policy into the hierarchy of designations, and then, as part of that, the distinction between creates valued landscapes and those which are not so described?
Yes, it doesn't reflect that distinction in the framework.
Thank you very much. And so again, to be national policy compliant, what test would we apply? CS5 or paragraph 170A, B, and 174A, B, and 175 of the MPPF?
You'd have to apply the framework tests at 174A, B, and 175.
Thank you very much. Let's then go to DM10, so the second document. Do you have that?
Yes, thank you.
DM10, not have an unacceptable impact on designated landscape character. It's the first bullet, and then reference to harmed landscape character is unavoidable. Development otherwise deemed beneficial, then mitigation measure will be secured by landscape condition. Yeah.
Yes.
In terms of that policy, again, first of all, is the distinction made, as we see in national policy, between the hierarchy?
No, there's no distinction in that respect.
And to what extent does the policy recognise that when one is going to have development of greenfield sites, there is acceptable adverse landscape impact, which then needs to be mitigated?
It doesn't assume any such baseline. It's a more generic policy in that respect.
Thank you very much. When we contemplate DM10 in the context of CS32, which does expressly contemplate stepping outside settlement boundaries, what do you suggest its approach of the inspector should be?
Well, in my view, DM10 has to be very much read in that context, that there is a nominal level of harm that is axiomatically connected to any development of a greenfield site on the edge of a settlement.
I'm very sorry to interrupt, but I'm having difficulty in hearing Mr. Marsh's evidence.
Apologies, was I probably
play-
glancing at the laptop a bit too much?
Yes, if you leave the microphone, then your volume drops.
Apologies.
Certainly.
Of course.
The approach to be taken to DM10 in the context that CS32 recognises development outside settlement boundaries on greenfield sites.
Yes, so I would suggest that the inspector has to take the approach that DM10 is read in the context that CS32 as the operative policy presumes a nominal level of harm arising as the result of converting greenfield land on the edge of settlements to housing. That's kind of the entry level of harm, above which harm should then be assessed for the purposes of DM10.
Thank you very much. And we know it's common ground between the parties. The site does not form part of a great valued landscape for the purpose of paragraph 174A
Yes.
of the MPB. Where does that place it then in terms of the hierarchy of landscapes and policy protection thereof?
Well, it thereby places it in the lower realms of landscape for the purposes of paragraph 174. It put it in within paragraph 174B, and therefore deemed less sensitive to change at that level.
Thank you very much. And in terms of providing mitigation measures secured by condition, either works on-site or off-site as necessary, to what extent does the inspector see that before him?
Sorry, could you repeat that last bit of that question?
DM10,
Yes.
the last proviso, where some harm is unavoidable but developments otherwise deemed beneficial, positive mitigation measures should be secured by landscape condition involving works on-site or off-site as necessary. To what extent does the inspector see that proposed as part of these, part of the PLA proposal?
I think it's clear through the parameter plans that have been submitted and in general accordance with which we would anticipate permission being granted for the purposes of the reserve matters, that such mitigation measures can and will be incorporated into the scheme in order to minimise the harm that element of the policy clearly allows for in practice.
Thank you very much. The next DM policy is DM32, which you'll find in this document at page 76.
I have it, thank you.
And just cast your eye, if you wouldn't mind, through. It's quite a long policy stretching over 2 and a bit pages. Remembering this is an outline scheme before the inspector, and you heard the evidence from the authorities' witnesses, they did not take exception to the design of the proposal, but rather the very fact of the proposal.
Yes.
And no objection has been taken in terms of the design and access statement, or any of the placemaking or beauty achieving aspects which would direct attention to section 13 of the MPPF.
That's my understanding, yes.
In that context, having regard to DM32, to what extent do you suggest that the authority's reason for refusal makes out an objection to DM32?
Well, I don't consider that it does. I believe, as we've heard in evidence, that the scheme is capable of satisfying that policy through appropriate reserved matters details.
Thank you very much indeed. Thank you. Right, so that was a trawl through the development management, development control policies, as it were. I want to go back now to the operation of CS32. So can you take that up, please, first of all? I first want your assistance with what you understand it to be allowing and not allowing, and then we'll see how the matter sits in terms of the MPPF. So CS32,
Yes.
new development within or adjoining the settlement boundaries of service villages, ... which enhances overall sustainability of the settlement will be supported where? Just break that down for a second. Within or adjoining settlement boundaries, to what extent does that bring with it policy-compliant ability to build outside the settlement boundaries of service villages?
Yeah, I mean that's clearly axiomatic of that second limb, the adjoining settlement boundaries.
Thank you very much indeed. And which enhances the overall sustainability of the settlement. You have within your appendices an economic impact assessment, or social economic impact assessment.
I do, yes.
We may need to come to it in a moment, but just in terms of that, in the broad headlines, to what extent does this proposal support and enhance the overall sustainability of the settlement by providing people and patronage for services within the settlement?
Yeah. Well, I consider that it does do exactly that. Aside from delivering a policy-compliant level of affordable housing, it also provides family housing, which would encourage residents of working age into an area which we know from the demography has an ageing population, and also we know from the ward level assessment has a disproportionately good growth in jobs. If I can
well,
put it in those terms.
why don't we go to it, because we haven't otherwise looked at this document in the inquiry. It's your Appendix 5, the economic benefit statement. And there's a couple of points to pick up, because we have the reasonably familiar provision of figures in the nice page full of diagrams, in terms of additional spend and so on.
Yes.
None of which, as I understand it, is in dispute with the authority. But at this stage, I'm more interested in the socioeconomic baseline, which is section 2 of the document.
Yes.
You got that? And there's a figure 2.1 that shows the population change. Wrington is the blue. Do you have that? And although there's a growth from 2011, can we see that there's actually been a dip since 2018?
Yes.
So Wrington on this graph is a declining population in total. Yeah?
Yes.
Table 2.1, though, let's just pick this up. Wrington population, again, this is from 2011 to 2020, so it does show a 3% overall growth.
Yes.
In terms of the working age population, and those anxious about retirement ages will just have to forgive me, the division here is still 64-65, isn't it?
Yes.
I appreciate even High Court judges now go on to 75. But traditionally, 64-65 is the division we've got here. 16 to 64, what's happened to that population over that time, despite overall growth?
Yes, so as you say, despite the overall growth, we see that 16 to 64 working age bracket has declined by 1.6%.
Yeah. And in terms of the over 65s, what's happened to that?
That has increased by 11.6%.
And what does that indicate to you in terms of the resource of workers within Wrington?
Well, that would suggest, relative to overall growth, a decline in workers, and in absolute terms, a decline in number of workers in that period.
Thank you very much. Now, if you look over the page, there's a heading called Employment.
Yes.
Have you got that? This is, of course, talking about the Wrington ward,
Yes.
not necessarily just the village itself, but the Wrington
understand, yes.
ward. We know that in Wrington village there is, the inspector will have seen the industrial estate and various other businesses as well. But if you go into paragraph 2.8, what does that tell us about the experience of employment growth between 2015 and 2020 in the Wrington ward?
I suggest that I'll read it out, lest I kind of diminish the quality of my colleagues' work. But between 2015 and 2020, North Somerset experienced an increase in employment of 4,000 jobs. That's 4.7% growth in jobs. This was above the corresponding growth rates in the South West and Great Britain of 3.2 and 2.4% respectively. And that's demonstrated in figure 2.3 of the page. Wrington Ward experienced an employment increase of 12.5% over the same time frame, equivalent to 500 additional jobs. With the labour market in North Somerset performing well relative to regional and national benchmarks, it is important to support a continuation of this trend. One way of doing this would be to provide new homes which can attract more economically active people to the area. This is a particularly important point to take into account, especially given the ageing population trend discussed in paragraph 2.6.
Thank you very much indeed. Looked at it from the other end of the telescope, if you have job growth, but you have a declining working age population locally, what does that do in terms of sustainability patterns of transport and journeys?
Well, in transport terms, if those jobs exist, then the employers will want to fill them and they will look further afield for people to come in and undertake those jobs. So in transport terms, that will probably give rise to more daily in-migration of commuters coming into the area, potentially from a greater distance further afield to do those jobs.
Thank you very much. And what's the outcome of that in sustainability terms?
Well, that's, in my view, demonstrably less sustainable than having people of working age within that ward doing jobs within that ward.
Thank you. Just go on to section 4 of the document, operational phase benefits. This is to do with spend.
I have it, thank you.
There's a table 4.1, and the matters on which spending is anticipated are set out in terms of headings, and a total given for the 61 dwellings of an annual expenditure of 1.956 million. Yeah?
Yes.
Obviously, not all the spending will necessarily be in the immediate local area, but there's an anticipation that a proportion of it will be. Thank you. In the light of those figures, and in the light of what you said about the employment and working age population situation, if we go back to CS 32, this is a proposal which is joining the settlement boundaries.
Yes.
And in your view, please, would it enhance the overall sustainability of the settlement? ...
I believe it would, yes.
Thank you very much indeed. Thank you. There are then the 7 bullets, and of those, little 1 and little 4 are said to be breached by the authority, but by reason of reason 1 and reason 2.
Yes.
Come back to that in due course. Then the proviso. Sites outside the settlement boundaries in excess of 25 dwellings must be brought forward as allocation through local plan and neighbourhood plan. Yeah?
Yes.
First point, please. Sites within the settlement boundary, to what extent is that caught by that last proviso?
It isn't. That's expressly for anything outside the settlement boundary.
Thank you. And so to what extent does CS32 numerically limit the number of dwellings to be brought forward within service villages?
It doesn't place any upper limit. No.
Or a given service village. Thank you. In terms of sites outside settlement boundaries, to what extent does that proviso limit the number of such sites at 25 and below?
It doesn't. I think that's a point borne out in the Rectory Farm decision, but that it doesn't preclude successive developments as a matter of principle.
Thank you very much indeed. Now that's in accordance with the process of neighbourhood plan or local plan. It could be brought, a number of sites outside settlement boundaries could be brought without having to go through that process.
Yes, and at any scale through that process.
Thank you very much indeed. Thank you. And so to what extent would it be correct to characterise CS32 as placing a numerical limit on the number of dwellings be brought forward either inside or outside settlement boundaries of service villages?
Well, it doesn't at an absolute level.
Thank you very much. Good. Let's, with that in mind, we know the proposal is 61.
Yes.
You don't purport that 61 is about 25.
I don't think that would be a very reasonable
Recognise
stance.
that it's in breach of that, and you characterise that as being a procedural failure, and we'll give weight to it in a moment. Yeah?
Yes.
Let's then, in the context of that, look at some decisions, please. So first of all, the right reference. Apologies. It's CD J.23, Cox's Green.
I have it, thank you.
You have that, and for this we go to paragraph 19. We'll come back for other purposes. Paragraph 19.
Yes.
Having considered the arguments put to me, I find that CS32 does not set any ceiling as to the level of housing development acceptable either within or adjacent to settlement boundaries. The reference to about 25 dwellings relates to proposals outside settlement boundaries and stipulates only that such proposals should be brought forward as allocations through local or neighbourhood plans. As the site is not allocated in the development plan, the proposals conflict with this procedural requirement. That's the way it's put there. Yeah.
Yes.
Is that those two propositions, one, the absence of a ceiling, and secondly, that the 25 is a procedural point, are they propositions you agree with or disagree with?
No, I agree with that.
Thank you.
That proposition, and
I'll come back to weight in a moment. Thank you very much. Can I then... Too many documents open in front of me. I've lost my... Here we are. Here we are. Forgive me. CD J22 is the next one. That's Rectory Farm. Do you have that?
yes, I have that, thank you.
And for this, we need to go to paragraph 43.
Yes.
Moreover, I note there's nothing in policy CS32 that would prevent, subject to appropriate compliance, the bullet points, 4 schemes of 25 coming forward over time. There is no numerical target to aim for or be constrained by. Now, that's a quote. It would appear to be from the evidence-in-chief of the council's witness, Mr. Underhay. No numerical target to aim for or be constrained by in policy CS32 as to the number of 25 dwelling schemes that might be granted permission. And the policy applies to individual applications, such that there could be a series of applications coming forward. Again, proposition you agree with or disagree with?
Yes, I agree with that proposition.
Which appear to have been endorsed by the witness for the authority. At the inquiry, Mr. Underhay acknowledged that if there's a need for 100 dwellings somewhere in Yatton, in principle, one single scheme may cause less harm and deliver more cumulative benefits than 4 scattered ones. Although the correct approach would be to pursue the proposals through local plan process, Mr. Underhay agreed if there's no 5-year land supply, there may be more scope in terms of numbers to be permitted in a scheme pursuant to CS32. Yeah?
Yes.
Again, a position you agree with or disagree with?
I agree entirely with that. I mean, I think it's readily accepted that development planned in a comprehensive way is usually better in its outcome than a more fragmented piecemeal approach. And obviously, numerically, and given the position with housing land supply, it's reasonable that some flexibility could and should be exercised in that respect.
Thank you very much indeed. Thank you. Then we're going to go to Farley Farm, which is the one that's not in the core docs.
Yes, have that, thanks.
And for this, we need to go to paragraph 96.
Sorry, was that 96?
96.
Yes, thank you. Yes, I have it, thank you.
Got it. And here, the reference is in the third line, in fact, to policy CS14, which we'll come back to in a moment. But CS14, which is where the sort of parent policy to CS31, 32, CS14 does not impose a cap on the number of dwellings that can be provided at each level of the settlement hierarchy. Yeah?
Yes.
Again, is that something you agree with or disagree with?
Yes, my understanding is that those numbers are expressed as a minimum at CS14.
Thank you. And then nonetheless, the approach to development within the hierarchy has been to set scale of thresholds to ensure development is appropriate for the size and character of settlement. In this regards, policy CS31-32 provides an allowance for development outside settlement boundaries of towns and villages. However, the fact that anything above 50 and 25 dwellings respectively must be brought forward through local neighbourhood plans has constrained the degree to which delivery can be brought forward outside the settlement, outside the site allocation process. And
Yes.
is that what's happened here?
Yes, I mean, I think the broad thrust of that sentence is that we are seeing the failure of that approach, some significant time on from initial adoption.
Thank you very much. So, out of all of that traipsing through the decisions, can we just summarise the position as you understand it, Mr. Marsh? Firstly, does CS32 limit the number of dwellings in total that can be brought forward in Wrington?
No, it doesn't.
Does CS32 limit the number of individual sites that can be brought forward under 25 or around 25 outside the settlement boundary of Wrington?
No, it doesn't.
And rather than a substantive objection, to what extent is the 25 not going through a neighbourhood plan or local plan a process point?
Well, it's squarely a process point, as obviously elucidated in the Cox's Green decision.
Thank you very much. Now, let's then go to the matter of weight. I hope we can do it crisply. CS 31 and indeed 32 derive ultimately from CS 14. Is that fair?
Yes, that's my
And
understanding.
CS 14 distributes the figures which are found in CS 13.
Yes.
And to what extent is it disputed? You heard again the evidence of Mr. Reynolds, disputed that CS 13's figures are not MPPF compliant assessment of development needs.
Well, I believe as Mr. Reynolds accepted in evidence, and I agree, they are not MPPF compliant.
Thank you very much. And what does that indicate, what does that mean in policy terms, MPPF terms, for whether or not CS 13, 14 and 32 can be considered up to date?
It means that they can't be considered up to date. They're out of date in their own terms.
Thank you very much indeed. And what does then that mean when we have regard to the Supreme Court's decision in Hopkins Holmes for the approach to be given to weight to them?
Well, the principle is then that their weight must be diminished in the planning balance, the degree to which is obviously a matter of planning judgment for the decision maker.
Thank you very much. And the consequence for the settlement boundaries, the adopted settlement boundaries on which they are predicated?
Well, because they are predicated, those settlement boundaries are equally out of date and can't be relied upon.
And as a result of that, the process objection to being in excess of around 25 in CS32, what happens to the weight for that in your view?
Well, in my view, certainly it must be diminished, and I would suggest in this instance that it can be given no more than limited weight, given its terms.
Thank you very much. We haven't been to the Moore Road decision. Let's just pick that one up. It's CDJ20, J.20.
Yes, I have it, thank you.
Do you have that?
I do, thanks.
And if you go to his main issue 4, the inspector here, and paragraph 68,
Yes, I have that, thank you.
we see that CS 13 and 14 and 32 are mentioned at paragraph 67. Dealing them in turn, it's common ground just noted the adopted core strategy does not include a framework compliant assessment of local housing need. To my mind, this means policy CS 13 is clearly out of date, as is policy CS 14 which simply seeks to distribute its out-of-date housing figure, having regard to settlement boundaries, which self-evidently also have to be seen as out of date. As CS32 also makes reference to settlement boundaries at the time of adoption, the core strategy, I consider it too has to be considered out of date. You see that?
Yes.
For his purposes, those weren't the most important because that was an allocated site. But in terms of the approach to that sequence of CS 13, 14 and 32 being out of date because they're founded on out-of-date assessment of development needs, what is your view?
Well, in terms of that sequence, it's equally applicable in this instance, as you indicate. They weren't deemed the most important in that instance, but we are not dealing with an allocated site here, so I think that same process stands up here.
Thank you very much. That's Moor Road. Rectory Farm, we said we'd come back to it at CDJ22.
Yes.
Actually, no, forgive me, that's out of sequence. We'll come back to that for a different purpose. Cox's Green is the one I want to go to. J23.
I have it, thank you.
So, and here it's paragraph 12. And you see the bottom part of paragraph 12 on page 2. The settlement boundaries for Wrington and other villages carried forward from a replacement local plan, established in the context housing requirement 2011, not the product of a full objective assessed needs. The council and appellant agree the boundaries are time expired and not up to date.
Yes.
Got that? And then paragraph 16, CS 13, developable land for 20,985 dwellings, not based on full objective assessment.
Yes.
You got that? And so again, the approach to be taken in the context of the absence of an objective assessment is what?
Well, the process is that those policies can't be deemed up to date and their weight must be diminished accordingly.
Thank you very much. And then Farley Farm, paragraph 96.
I have it, yes.
Housing requirement in policy CS 13 is out of date. Consideration must be given to whether spatial strategy supporting policies are soundly based. And then he runs through the points we've already seen. Yeah?
Yes.
And so before we get to the question of 5-year land supply, to what extent is the strategy of the authority, as expressed through CS 13, 14 and 32, up to date or out of date?
Well, the strategy as a whole is out of date on that basis.
Thank you very much. Lastly, we now are in agreement that the housing land supply cannot be demonstrated by the authority. The figures are a little bit inchoate, but they're somewhere between your 2.95, 3.2 and 3.5 years.
Yes, yeah.
And it's agreed the inspector doesn't need to concern himself with the precise figure because the shortfall is significant.
Correct,
Yeah.
yes.
And the consequence of that is what for footnote 8?
Well, footnote 8 then directs that the policies, the most important policies, will be out of date, and obviously determination would proceed in the context of 11D of the framework.
Thank you very much indeed. And in the light of that, either by virtue of the settlement boundaries and the strategy being out of date, or indeed through the 5-year land supply footnote 8 route, what weight is to be given to the procedural breach of the above 25 not coming through neighbourhood plans?
So, I mean, owing mutually and independently to those two factors, in my view, only limited weight can be ascribed to any breach of that final paragraph in CS32.
Thank you very much. And to what extent is that view endorsed by the inspectors in particularly Rectory Farm and Cox's Green that we've seen?
I'd say that position is very closely aligned with those two decisions in particular.
Okay, thank you very much indeed. Thank you. Now, plainly, I'm not going to rehearse with you the heritage and the landscape points. I want to come to the planning sequence now that we need to go through. Section 38.6, there is breach of that last proviso of CS32, as we've seen.
Yes.
Yeah. We have the MPPF as a material consideration, as indeed is the up-to-dateness or otherwise of the policies in question.
Yes.
Yeah. You've identified the policies are out of date in their own terms, and also in terms of footnote 8 and the absence of 5-year land supply.
That's correct, yes.
In terms of paragraph 11, where do we then go?
Well, that directs us to 11D, and we are then in 11D thereafter.
Thank you. We're very familiar, all of us, I'm sure. 11D has two parts.
Yes.
Little 1, are there clear reasons for refusing by reference to a series of other footnoted criteria, including impact on designated heritage assets?
Yes.
We go off to paragraph 202 of the MPPF in our circumstances, and your view as to whether that test is passed or failed.
Yes, in my view, that test is passed, the reason being that we will be balancing the public benefits of the scheme against the degree of harm, which in this instance, as a matter of agreement, is at the lowermost end of less than substantial, and thus that balance, in my view, is concluded in the proposal's favour.
Thank you very much indeed. Just help me with this. Do you find that to be a narrow passing of paragraph 202, comfortable or significant passing of 202?
I would say it's a very significant, very comfortable passing of that test, and that is principally due to the extent and range of benefits that I've identified in the relevant section of my proof.
Thank you very much. Having passed 202, you observed earlier that means the scheme is policy compliant in terms of national policy for protecting the heritage built environment. Where do we go next?
Well, as I believe that it's a matter of agreement, there's no other of those policies identified at footnote 7 that would cause one to disengage the tilted balance by dint of 11D little 1. You would then proceed to determination under 11D numeral 2.
Thank you very much. And here, all the benefits and all the negatives are thrown back into the balance, but on a tilted balance, the negatives must significantly and demonstrably outweigh the benefits.
That's correct, yes.
If permission is to be refused. Here we have, in addition to the lowermost end of heritage harm, we're told there is also a landscape harm,
Yes.
characterized at year 15 as being only moderate in terms of the site and its immediate surroundings. That's, as the authority puts it, obviously less for the appellant, and to a not a, quotes, valued landscape for paragraph 174A of the MPPF purposes. Yeah?
Yes.
How do you strike the balance, please, Mr. Marsh?
Well, I think in this case, to glean your terminology from last Friday, it's a case of calibration. In this instance, we have at worst a moderate degree of harm in the long term, and that is to a landscape that is at that lowermost end of let's say our scale at 174. It falls into 174B, not 174A. Taking those two things together, it's clear that there are many degrees of more sensitive landscape and many degrees of harm above where we sit on that scale, and therefore I consider we couldn't give any more than limited weight in the overall planning balance to those effects.
Thank you very much. Now, you recall Mr. Reynolds then sought to add to reason 1 and reason 2 a further significant negative, which was breach of the last part of policy CS32. she gave significant weight to. Just help me with that, please. First of all, as a matter of principle, your view as to whether or not policy CS32 is supportive of development outside settlement boundaries of the nature we're here proposing?
Well, it's plainly supportive, A, of development outside of settlement boundaries, and B, of development of a significant scale in excess of 25 dwellings, subject to a procedural distinction. But in terms of development in and of itself, it's clearly an enabling policy.
Thank you. And in terms of that last point, that procedural point in excess of 25, to what extent would it be consistent with the decisions we've seen, quite apart from your own view, to give that breach more than limited weight in the context CS32 is itself part of an out-of-date spatial strategy and there isn't a 5-year land supply?
I feel, having regard to those decisions, the more historic of which are obviously taken in the context, I believe, of a slightly larger housing land supply figure, it would be entirely consistent to take that view that only limited weight should be ascribed to that conflict.
Thank you very much. Mr. Marsh, is there anything else at this stage you want to cover?
I don't believe so, thank you.
Thank you very much. Thank you very much, sir.
Thank you. I'm just contemplating whether to take a short break now. I think I'm casting my mind back to your estimate, Mr. Wadsley. Was it around the hour mark for cross-examination? What are you thinking now? Yes.
Excuse me. I'm thinking that around about an hour is probably right. I'm not giving any guarantees because I don't know how Mr. Marsh is going to answer my questions and what supplementary questions may arise as a result. But that would be my estimate.
That's a fair way of putting it. And then, of course, on top of that, we'll have anything from Mr. Storer as well. I think we will just take a short break until the hour, until 2 o'clock, just to sort of compartmentalise things rather than you trying to find a suitable break in things. And it will give us a short comfort break. So we'll adjourn now until 2 o'clock. Thank you. Okay, it's 2 o'clock by my watch. I think everybody's back who needs to be here. So, yes, can we have your cross-examination now, Mr. Wadsley?
Thank you very much. Mr. Marsh, can we look at one or two matters that you dealt with in your oral evidence just now, before I come to the main sequence of my questions? Your interesting sustainability assessment for Wrington, the coloured wheel on page 5 of your main proof of evidence, I'm going to refer to briefly. You indicated that Wrington was 9th out of 22 settlements. Wrington, of course, is a service village. So putting in its category of service villages, where does it come in those? Do you know? Because my information is that it's low down. 8th out of 9, in other words.
Yes. Yeah.
Yes, thank you. Okay. And the wheel is, according to your proof, was revised in July 2016, which of course is roughly 6 years ago now. And you'll have heard the evidence from local people last week when they indicated the way in which services had declined, shops had shut, the post office, the separate post office had gone, doctor's surgery and so on and so forth. So if we're going to take on board what is said there, we have to bear in mind that there's been a change in circumstances since 2016, don't we?
We have to take account of any changes in circumstances, but that will often be the case for these villages, that services will come and go, and naturally we understand that there will be pressures, I think particularly where you have declining working age population to support a lot of those things. Per paragraph 79 of the framework, there is an interrelationship. I think Mr. Jones quite eloquently put it as a support network this morning. And that interaction between villages, but nonetheless, Wrington remains a service village and, in our view, well served for incoming new residents and housing.
Yes, you refer to an interaction between service villages, and I take your point, but nonetheless, this is predicated on Wrington itself, not on the interaction, isn't it?
We are principally looking at accessibility and availability of services within Wrington. But I mean, I don't believe that those services have substantially reduced since the time when the council determined the application, at which point there wasn't such a case being put. Okay,
well, the inspector will have to make up his mind, having heard your evidence and the evidence, obviously, of the villagers and
yes,
what they said about it. Okay. Your Appendix 5, I think it is. Yes, it's the one which has the charts and so on and the evidence you gave about job growth. It refers to the ward of Wrington. Of course, geographically, the ward of Wrington is a very large area indeed, isn't it? It's much, 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 much more than the village itself.
It's significantly wider than, let's take the framework boundary of the village, say, yes.
So, for example, one example of the width of the ward, it includes Bristol Airport, doesn't it?
It does.
It does. I mean, you're saying yes or no. I didn't catch. It's just the same problem I've had before. I think you're moving away from the mic. It's difficult, I know, but
apologies. Offhand, I don't know. I'm willing to be told that that is the case if that is correct.
I've seen a map of the ward, and I've seen a map of the ward which includes at the northeastern periphery Bristol Airport. But you see, on the assumption that's right, and if you want to come back to us outside the inquiry and say it's wrong, then we can tell the inspector, obviously. But on the assumption that's right, then a leap in job growth would be easily explained by, for example, job growth at the airport, which is expanding, as we know.
Yeah, I mean, that could very well be one explanation. It's clearly a major employer, and yes, and once expanded, we'll assume that those job numbers will increase all the more. However, we can still take from that we are looking to contain the relationship geographically between residents and employment, still to a relatively contained area compared to, for instance, those employees gravitating from Bristol on a daily basis to get to the airport?
Well, yes, it doesn't follow, of course, that the employees at the airport would live very close to the airport, or for that matter, live in Wrington. I mean, they might live, for example, in Backwell, which is not a distance away from the airport, and is a much larger service village. They might live in Bristol, and so on and so on and so on. So the simple point about this is that when you're looking at an expansion of a service village, and I'll be coming back to this point in a moment or two, when you're looking at the expansion of a service village, one of the things that it's sensible to look at, and the local plan urges people to look at, is whether an application like this should be dealt with in a Section 78 appeal, or should be dealt with through a local plan or neighbourhood plan allocation. Because if you do that, in the local plan allocation, for example, you're able to factor in where, with competing sites, a particular allocation might better go, aren't you? You can't do it on this appeal.
Yes, I mean, I would say, broadly speaking, that one, in going through an allocations process, one is undertaking some of those sustainability appraisal points that one will quite rationally do in the preparation of a scheme such as this.
Yeah.
And broadly, it's a comparable exercise.
Good. Let's have a look. I'm going to develop that point in a moment. Let's have a look at CS32. You've looked at it once already. I'm not going to take up a lot of time on this because of what the evidence you've been giving. Page 130 of core document A1, I think I'm right in saying, yes?
I have it, thank you.
Thank you. I think this is a matter of complete agreement. We accept that what is in play in CS32 is not just the last two lines, line and a half at the end, about 25 dwellings and so on, but also what is also in play is bullet point 1 and bullet point 4, which relate effectively to landscape and, I don't doubt as well, heritage harm, given the width of the words. So those are the things that we have to look at, yes?
Yes, I understand that the council is taking the case that it encapsulates points 1 and 4 specifically on this as well.
Yes, okay, good, thank you very much, well, that's helpful. And one matter that we ought to consider is that there's no, as you quite rightly say, there's no explicit cap on numbers because the last line and a half refer to sites in excess of about 25 dwellings must be brought forward through local or neighbourhood plans. So there's no explicit cap, though it's fairly obvious, isn't it, what the policy is seeking to achieve?
I mean, I think that procedural requirement at the end is set out in very definitive terms that are kind of very.
We'll look at whether it's a procedural. Sorry, I beg your pardon. Didn't mean to interrupt you. We'll look at whether it's purely procedural in a moment or two. But what I was going to invite you to consider as well, in the light of your evidence, is the. Sorry. Just bear with me a moment. Yes, is look at the 1, 2, 3, 4, the 5th bullet point, because you're right. There's no explicit cap on numbers, but the 5th bullet point says it does not result in significant adverse cumulative impacts, such as highway impacts, likely to arise from existing and proposed development within the wider area. So, if you're looking, for example, at a series of applications outside the settlement boundary and in and around Wrington, on the basis that they come within CS32 and so on, then one of the factors that you would have to take into account, isn't it, is the cumulative impact. You would?
Yeah, yes, and obviously that's been touched on this morning, noting the reference to highways impacts. That's obviously not a matter of issue.
Well, it wouldn't just be highways impacts, 1, 2, 3, 4, 5, because highways impacts is given as an example, such as highways impacts.
Yes.
So it could be other impacts as well. Could be other impacts on services, might be cumulative landscape impacts, might be all sorts of things, mightn't it?
Could be, yes, of course, yeah. I just cited highways because it's the example given, but I
Sure.
appreciate
No.
that's not exhaustive.
Understand. I may have misheard or misunderstood your evidence, and in which case it's my fault. But I thought you were saying that the overall effect of CS32 was that it accepted necessarily, because it allowed development outside the boundary, a level of harm to the landscape. Did I understand you correctly?
I would qualify that by saying that I believe the question was put in the context of the interpretation of policy DM10, and I asserted that DM10 in this context and other contexts in which CS32 is the operative policy, that DM10 would have to be read having regard to the operative policies anticipating inevitable impacts arising from greenfield land becoming housing adjoining villages, and that would establish a kind of baseline level of harm. So while that's not expressly set out, of course, in CS32, that would be the context in which one should interpret and apply DM10 in this instance.
Yes, I understand where you're coming from, except that, just bear with me a second, DM10 refers to an unacceptable adverse impact, doesn't it?
Just bear with me, I'll just dig out the policy.
Sorry, it's page 28
No
of the...
problem. Yes, I mean, I think specifically with DM10, obviously one would have regard to that final paragraph about where some harm to the local landscape character is unavoidable. I think it would be reasonable to assume that landscape assessment being formulated as it is, as a matter of best practice, we are already into that territory at the point at which we are looking at greenfield land going to housing on the edge of settlements.
Yes, but there's no conflict with DM10 because DM10 refers to unacceptable adverse impact. So DM10 itself accepts that there may be an impact and it may be an adverse impact, but it's got to be an unacceptable adverse impact, hasn't it? That's what it says.
Should not have an unacceptable adverse impact. Yes, one of the criteria there.
So what I'm putting to you quite simply is this, is that DM10 has its own fail-safe mechanism within it, just as CS32 does. Because CS32, if we move to that policy now, that also requires that the form, design and scale of development, the first bullet point, with a high quality, which is high quality, then it goes on, respects and enhances the local character, contributes to placemaking and the reinforcement of local distinctiveness. And then the fourth bullet point, high quality sustainable scheme, positive contribution to local environment and landscape setting. So in both those policies, there is a fail-safe element. It accepts that development may take place, but only on certain terms. And in the case of DM10, the certain terms are the unacceptable adverse impact. And in CS32, the certain terms are what we've just looked at, aren't they?
Well, I mean, in terms of the criteria we've picked out from CS32, you know, I'd emphasise that those are read in the round with design and layout considerations as well, and they don't begin and end a landscape. But
yes, yeah. I mean, clearly, the reason I didn't pick out design was because I'm not taking a point on design, and
I understand.
The council hasn't taken a point on design. Okay. So, I don't think I was going to take you back to CS14, the earlier policies, but I don't think I need to, because just very briefly, and just to make the point I had in mind, and it doesn't detract from, I think, anything you said, CS14 talks about the distribution of housing. It's accepted that is, for the reasons that have been given, out of date. But what it does also is to refer to service villages where it says there'll be opportunities for small-scale development abutting the villages. But as you said, I think in your evidence, it doesn't itself give any limit on the size of such development, does it?
No, not in that policy.
Thank you very much. So that's CS32 in context. And if we just yeah, I mean, if we just to pick up on a point I made in a question to you a moment or two ago, if you just go to the justificatory text of CS 32, which is on page 132,
I have it, yes, if you want
Thank you
to point me
very
to
much.
a paragraph.
yeah, paragraph 4.89.
Thank you.
It refers to the policy and about larger sites being brought forward. That's the second sentence. Then it goes on to say the purpose of the policy is to allow small-scale residential developments to come forward, etc., etc., etc. In this respect, last sentence, I think, the cumulative impact of development will be a significant consideration, and a succession of piecemeal developments which individually or taken together have an adverse effect on any individual village are unlikely to be supported. Now, I appreciate that is not policy but is text, justificatory text, but it is a guidance to the way in which the cumulative impact point in the policy itself can be judged, doesn't it?
It does, and I would, hasten to add that I think that's a very reasonable consideration for any development, and in almost any respect that would look at reasonably at cumulative impacts with other committed development in the immediate vicinity. But I think this is probably exactly the point that the Rectory Farm decision is getting at in its discussion, in as much that one well-planned comprehensive scheme is likely to yield, not necessarily, but is likely to yield a better result overall than a successive piecemeal approach. And I note that obviously we are talking about whether those developments in that final sentence of 4.89 supporting text, we're talking about whether those succession of developments would have an adverse effect on the individual village, as opposed to them being in some way harmful, simply as a function of being several phases, say.
So to interrupt, I didn't catch the reference to the appeal you mentioned there.
Sorry, that was in...
Was it Rectory Farm?
Rectory Farm, in relation to, I believe
No,
Mr.
it's just, I've
Underhays.
got that. I just didn't catch which appeal. Thank you. Sorry to interrupt.
No problem.
Yeah. So, I mean, what we're struggling with here, or trying to sort out here, is in relation to CS32. I'm going to suggest the tension on the one hand between the lack of a 5-year housing land supply, so that housing must be brought forward, and the other thing that we're struggling with is, of course, the impact on the environment, by which I mean in this context the landscape and the listed building. And it is that tension, isn't it, which the local plan inspector tried to resolve in dealing with the main modifications. Can we go, please, to A4, core document A4, which is the local plan inspector's report in respect of the main modifications?
Yes, I have it, thank you.
Thank you. And it's bear with me a second. Yes, it's first of all, it's paragraph 37 on page 13, where the inspector, in his paragraph 37, is dealing with the main modifications in relation to various policies, but including policy CS32, and that's main modification 5. And he recalls the fact, this is in the sentence just below the bold text, it is true, he says, that some schemes in excess of these figures have in the past been granted permission on sites in Yatton and elsewhere. Then he says, but the council is perfectly in its rights, in the interest of the proper planning of the area, to put a figure on the maximum size for individual developments on unallocated sites that it considers compatible with a settlement hierarchy and spatial strategy. And then he explains what the policy wording, which we've looked at, will allow to be done In other words, give a degree of flexibility and reduce the risk, doesn't say eliminate it, but reduce the risk of housing undersupply. So that's the inspector setting the scene, is it not?
Yes, I mean, I would say in that instance, as you correctly identify, the objective there is, and as set out in the following paragraph, is to allow flexibility in that approach. But I would make the point that obviously this is the inspector's report, which at the time was assuming an early review of the housing policies, which we obviously know has not happened. But at that point in time, I do accept that obviously that was the strategy that the inspector was endorsing.
Well, that's what gave rise to the policy, and it's important, isn't it, to look at the background and understand how this came about. Because you refer, for example, and in fairness, I think it was the Cox's Green inspector started the ball rolling by referring to the procedural limitation in policy CS32.
Yes.
And so I understand, I quite understand why you picked that up. But I'm going to suggest it's a little more than that in a moment or two. So let's just go on with looking at what the local plan inspector had to consider. Paragraph 39, the categorization of service and infill villages has been the subject of an analysis by the council in a document which he refers to. And he points out that settlements vary widely, issues of consistency may arise, but he considers that the document the council produced contained a substantial amount of survey data, and it's clear from evidence and on the ground that the classification is a reasonable reflection of the size and range of services of the various settlements. So this wasn't just somebody drawing a bird, a venture, and in effect sticking their finger in the air and saying, well, this is what we'll do about the service villages. It was properly analysed, and the inspector recalls that the analysis was a sensible one, doesn't he?
Yes.
So, if we then move on, having set the scene, move on to page 18 and policy CS32, which of course is the policy that we're concerned with about service villages, we can see, can't we? First of all, there's the reference to policy CS14, so that policy CS14 gives us the housing requirement, out of date we accept, and so on. And then he says, 69, neither significant restrictions on housing development nor substantial amounts of additional housing represent a sound or balanced approach towards settlements which contain a range of services and facilities, but which are in essence still villages. So the inspector is telling us there that as far as the council's approach is concerned, it would be wrong to have significant restrictions. On the other hand, it would be wrong to have substantial amounts of additional housing. That's the start of it, isn't it, as far as he's concerned?
Yes, and I think emphasis has got to be placed on that word substantial.
Yes.
To my mind, that is of a very significant size.
Well, the significant size will depend upon the village, or service village more accurately, in question. I mean, for example, if it's Yatton or Banwell, or one of the largest service villages, I always get my service villages wrong, because I'm...
So Yatton's a good example.
Yatton's 7,200 population, I think Backwell is 4,500, Banwell is nearly 3,000, and Wrington is near the bottom, not quite at the bottom, but it's 2,600. So, obviously, when you're talking about substantial amounts of additional housing, much will depend upon the context, the village, service village in question, won't it?
Well, that will certainly be relevant, yes, although it's obviously significant, I think, that the 25-unit procedural trigger doesn't differentiate within that broad group of service village settlements.
It's perfectly true it doesn't, but no doubt a developer would say perfectly properly, well, this trigger should be quite different in relation to Yatton than, say, Wrington or Churchill, which has fewer residents than Yatton, 2,250 apparently. So then he goes on, there is no reason why development of a relatively modest scale adjoining settlement boundaries should threaten the character of villages. However, larger scale schemes or substantial cumulative growth, so that's back to the policy point we were looking at, will be more likely to alter the character of the villages, place undue burdens on infrastructure and the road network, and threaten the spatial strategy. It's not without reason that these concerns have been raised by a number of communities. So, pausing there for a moment, you can see, given the inspector's reasoning, why he accepted or recommended that the main modification should include what we have at the end of the policy, namely that in certain circumstances the allocations should be dealt with in the local plan context. Because that allows the local plan context to say, for example, not at Wrington, but better at Yatton, or not at Churchill, but better at Backwell, and so on. I mean, that's the point about it, isn't it?
I can see, certainly, the sense of what the main modification was intending to do in the context of the formulation of that policy, certainly. And, you know, I wouldn't disagree with the sentiment that it would be more likely to alter the character of the villages, but that is not to say inevitable, and that's not to say that that wouldn't come until a point where a village was, for want of a better word, saturated with new development.
But the point I'm putting to you really is this, and it's in context of the use of the word procedural, which has a sort of, or may have, to some, a pejorative ring. It's not just descriptive, it's just indicating, well, this is a matter of procedure, and this is the way we deal with procedure, and we don't have to worry about the substance. Substance is often the counterpoint to procedure. And what I'm suggesting to you here is that the way that the local plan inspector and the local authority following him, the local plan inspector, dealt with this is to make it clear that there was a good and sensible reason for the proviso that we have at the end of CS 32 about dealing with things in the local plan context. That's fair, isn't it?
I'd say that is fair, and I would hate for there to be any inference that we're regarding it as simply a troublesome piece of red tape and that it doesn't really matter in the grand scheme of things. We accept that there is a procedural conflict there and that there is a justification for that policy. On the other hand, we are, of course, considering that policy in the context with a spatial strategy which we say has failed in and of itself, which is, of course, something that the inspector directing those main modifications would not be aware of at that point in time.
Yeah, well, let me just deal with that. It's slightly out of context of my questions, but it doesn't really matter. Yes, it's the conflict between a sensible strategy and the problem with the strategy where there's no 5-year housing land supply. But that doesn't mean, does it, that you throw the baby out with the bathwater. In other words, if you have got a strategy which has been sensibly devised, and clearly in context this was, if you've got that strategy, then you don't abandon it merely because there is a shortfall in housing land supply. Because the problems that you have in bringing forward sites are exactly the same, aren't they, in relation to the individual settlement?
I would agree that the broad principles and the context into which you're introducing that development is, kind of consistent. Things aren't physically going to change on the ground just because of the wider housing land supply picture. But I think that the key point there is that, this is still a procedure that has been put in place to allow some flexibility, and that flexibility hasn't proved sufficient through that entirely plan-led approach to deliver the housing anticipated by the plan and on which that policy is predicated.
But in deciding the weight, well, the inspector has to decide the weight that has to be given to a particular policy. Can I suggest to you that, first of all, the context of the policy and the way that it was devised and brought forward is important, and that also the purpose that it seeks to achieve is also important. And one of the purposes, perhaps the most important purpose it seeks to achieve, is avoiding a plethora of unacceptable development in particular villages, which might, if considered in the local plan context, go more acceptably elsewhere. For example, at a larger village, or for example at, let's say, Nailsea or Clevedon, their towns, Portishead. Do you see what I mean?
I do see what you mean. Yes, and as I say, there is an expectation that one would wish to ensure that development is compatible with its location. In that respect, we consider that it is in this case, and conflict with the procedural requirement at CS32 doesn't stymie that.
Thank you. Just to round this off, and then we can probably put this away. Paragraph 70, the inspector then refers to the modification, which is the one we know about, the one that's in the policy, obviously. And he says, halfway down the paragraph, it also aims to limit cumulative impacts. It indicates the sites in excess of about 25 dwellings outside the settlement boundaries must be brought forward as allocations. This is neither too restrictive nor too liberal. It is a sound modification that allows the service villages to contribute more to the overall requirement, whilst avoiding development of an excessive scale with the negative impacts described above. And then he says the MMO5, modification 5, is required to make the policy sound. So that sums up, really, the inspector's approach and what was the genesis of the policy, does it not?
Yes, I think that's a clear account of the intention at the time, absolutely.
Yeah, well, I mean, you say things have moved on because we've got a lack of a 5-year housing land supply. And all I'm suggesting to you is that the inspector must very carefully take into account, when attributing weight to policy CS32, which we agree is out of date, when attributing weight to it, he must very carefully take into account the way in which the policy was devised and the purpose for which it was devised. And that's fair, isn't it?
It's relevant to consider that, certainly, yes.
Thank you very much. Okay, right. Having dealt with that, oops. We may be able to deal with these other matters relatively quickly because they're discrete points. I hope so in any event. So let's see how we go. And I suppose one would add to the way in which the policy was devised, the way in which the policy has in fact operated, because of course we have the grant of planning permission, at Cox's Field, on appeal, I recognise, but on appeal, but grant nonetheless, and also, although it's technically not under CS32, we have the grant of planning permission at Gatcombe Farm, just outside Wrington.
Well, yes, I mean, I think in that respect we do have to treat that with a degree of caution, being something of a policy and geographic outlier being considered in the context of firmly CS33 and the open countryside.
Yes, well, it's a brownfield site, obviously. Yeah.
It is, yeah, I'm not commenting on the merits of the decision.
No. Yes. Can we have a look? I just want to see it. Maybe I've dealt with this already, in which case I won't trouble you, obviously. It's your policy paragraph 9.52, little Roman 6. Yes. You say that there has been very limited growth, particularly in respect of speculative development at Wrington. Well, I referred to Cox's Field and granted outside the village Gatcombe Farm. But given the relative size of Wrington, I mean, it wouldn't be surprising, would it, if much more development or many more applications had come forward at places like Backwell and Yatton and so on?
Well, I mean, I'm not a developer, and therefore I can't comment on necessarily the reasoning for the varying picture across the unitary area in terms of those other villages. But I do think it's relevant and fair to observe that there have been substantial changes elsewhere. Certainly, that would align with the assertion that this is not a disproportionate addition to the village of Wrington.
Well, that may or may not be right, but it also makes the point, doesn't it, that if you're going to have development elsewhere, it is also sensible that they're considered in the context of a local or neighbourhood plan.
Well, I mean, I think all of the discussion we've just rehearsed
Yeah.
in terms of that inspector's report would be no less relevant to any other settlement as it is to Wrington.
In your paragraph 7.11, I think that's the one, that's what my note tells me, so I hope I'm right. Yes, you're referring to policy DM3 and DM4 on the conservation area and listed buildings, and you say it should be noted, this is your 7.11, that neither policy is compliant with the framework in that neither allows for a balancing exercise to be undertaken in relation to harm to heritage assets versus public benefits. So no paragraph 202, in other words. I mean, 3 points, I think. The first is that it isn't necessary, is it, for a local plan policy to slavishly follow the terms of national policy, word for word?
It is not necessary for it to do so word for word, but I think in this instance, this is a case in point where it's absolutely vital to recognise that the policy represents a stepping off point, and a fairly early stepping off point, in that it only really reflects what I would consider the front end of section 16 of the framework,
Yes.
which is broadly to say that heritage is a good thing, but doesn't go on to reflect the balancing exercise required by the framework.
But the council in this case carried out the balancing exercise, didn't it? I mean, you may not agree with the way it did it, but it did it in fact.
Yes, yeah.
Yes.
In point of fact, I have no issue that was ostensibly set out in the officer report.
Yeah, so it's not a question of that the council have made a ridiculous decision and have completely forgotten one important element of policy. They carried out the balancing exercise. And the second point is this is an up-to-date, subject to housing land supply and so on, but otherwise this is an up-to-date local plan. And the local plan inspector didn't seem to be terribly worried by that, did he or she?
Well, I can't speak for the inspectors thinking on it, but clearly, the policy did survive to adoption. I consider that it is not a framework compliant policy for the reasons set out,
Yes.
which we've just discussed.
You see, I've seen nothing which suggests that the local plan inspector, when carrying out the local plan inquiry, said, hang on a second, these two policies really don't reflect national policy properly, so you've got to alter them, you've got to modify them. Nothing like that seems to have happened, does it?
It doesn't, no. And as I say, it's, I think, a matter of agreement between the parties that it is necessary to go a significant way beyond those policies, obviously only one of them being an issue now, and that they are read firmly in the context of Section 16 in the framework.
Yes. Oh, please don't misunderstand me. I'm not trying to make you agree that there shouldn't be a balancing exercise carried out. I agree entirely there should be, and I'm certainly not going to make any submission that those policies can be looked at without carrying out an appropriate balancing exercise. I'm not going to suggest that at all.
No, I understand.
No, thank you. In fact, of course, balancing the terms of one policy, be it heritage or landscape or whatever, against other policies supporting economic development and housing development and the like, that sort of balancing exercise is the one which local planning authorities are fairly obviously carrying out every day of the week, aren't they?
It's what it all comes down to into a final planning balance, yes.
Okay. And just one more matter which I should have dealt with under CS 32. I think it's the only one I should have dealt with. But the weight, I'm sorry, let me start again. The reduction in weight for CS 32 relates to the issue effectively of the settlement boundary only. It's not being suggested, I think, looking at the statement of common ground, that the other criteria in in CS 32, which deal with landscape and the like, it's not suggested that the weight attributed to them is or should be reduced, is it?
Well, I think we have to be careful here in as much as CS32 is unequivocally an out-of-date policy, and the framework obviously directs that in that context its weight must be diminished to some extent to be determined by the decision maker. It is our case that certainly in as much as it pertains to the scale and distribution of housing within that policy, the critical limitations, the critical restrictions of that final paragraph of CS32 are really the critical and perhaps, let's say, most out-of-date element of that policy, and therefore should only be afforded limited weight. But that it is reasonable, that weight is potentially differentiated through that policy depending on the degree of conflict.
Okay, well, let's help the inspector. Would you go to page 34 of the Statement of Common Ground, and there's a helpful table there which sets out, it's Appendix 3, comparison of policy and planning balance weight positions. And then
So
if
sorry,
we go
you have to bear with me a moment.
Sorry.
Sorry, Appendix 3, I have it, thank you.
And page 34, then we've got various policies, then policy CS32, council position, substantial weight, so easy and straightforward, which you won't agree with, and then appellant position, substantial weight to the listed bullets, which is the landscape stuff that I've been etc., which I've been referring to, but limited weight to the 25 dwelling windfall threshold. So that's the settlement boundary point, isn't it?
The latter,
Yes.
yeah. And those other points, I think, as we've previously discussed, obviously go to related issues of heritage and landscape and so
Yes.
on.
Yeah, but it's the bullets that achieve the substantial weight from your point of view, and the limited weight is attributed to, well, what I call the settlement boundary issue, but you may want to describe it in a different way, I don't know.
I believe
Okay.
we're talking to the same thing, so I'm quite happy on the nomenclature.
Good. Well, that's the Statement of Common Ground. Thank you very much indeed. That's helpful. Right. I mean, I just want to raise this with you quickly because doesn't, I think, deserve a huge amount of time. But between the part of the eastern boundary of the appeal site and Butts Batch itself, there is a paddock which is not part of the appeal site, but it is shown in the master plan and I think elsewhere as having an entrance from the appeal site to the west and what appear to be indications that development will be carried out on this. Is this something that your clients are going to deal with in the future?
I have absolutely no idea is the blunt answer to that. Obviously, the parameters plans indicate how the site could be developed, and that obviously there are facilities there potentially for a turning head with, I suppose in principle, further potential. As far as I'm aware, there's been no advance towards such a scheme, which would obviously be considered on its individual merits. I don't believe that it's germane to the determination of the appeal before us.
No, the inspector doesn't have to decide that. I quite agree with you. Just wanted to know because it's on the documents, you see. Anyway, move on from that. In your 322, this is just a discrete point. It touches on sustainability, but not in any major, well, not in any fundamental way. Important, I think. In 322, you say bus stops are located approximately 200 metres northwest of the site at Butts Batch, providing access to a daytime service that connects to Weston-super-Mare, from which bus and national rail services to Bristol and elsewhere can be accessed. Well, help me with this. I understand that the bus service is the number 51, which runs hourly on Mondays to Saturday and no Sundays. Have I got that right?
I'm afraid I can't confirm that. I know this was discussed with Mr. Jones this morning, but my knowledge of the most up-to-date bus timetable is a little bit lacking, I'm afraid.
Well, okay, well, it's in your evidence, you see, which is why I asked you. The first bus, Mr. Reynolds indicated when he gave evidence last week, leaves Wrington at 08:45 and arrives at Weston-super-Mare at 9:39. I mean, if people were looking to live in Wrington and work in Weston-super-Mare and travel by a reasonably sustainable method of transport, then from a commuting point of view, it would be, well, it wouldn't be very helpful, would it?
I suppose it's a broader question, and it's down to individual choice, whether someone wants to instead get in the car, have a shorter drive, then potentially have to find a parking space or pay quite a, dare I say, a hefty fee to park for the day, would be another matter of choice. However, the ability to sit in peace on a relatively reliable piece of public transport for 45, 50 minutes on their way to work might well appeal.
The other thing I think that Mr. Reynolds did say was that there had been a bus service much more regular and with better hours, which was the Flyer bus service, Flyer A, which linked Weston-super-Mare and Wrington and other villages with Bristol Airport, but that has been discontinued. So you see, what I'm putting to you here is that this is one of the things where, since 2016, and the chart on your page 5, the sustainability, in certain respects, bus services, appears to have declined rather than increased, doesn't it?
I mean, in fairness, I would say it does appear that way. I would say that is by no means limited to this location. It's a pretty universal picture, except in those small pockets where we've seen significant additional investment. I understand, the Bus Back Better scheme is intended to improve these kind of services, as indeed will the sizable contributions derived from the Bristol Airport expansion, which I appreciate are yet to be allocated, but would in theory provide for links through the nearby villages. And I think having a resident population that is able to economically or viably support such a service is obviously absolutely key, and it's where some villages or many settlements indeed do struggle.
Yeah, well, the point really is that at any rate since 2016, in certain respects, the services the villagers say, and the bus service perhaps corroborates them, seem to have declined, and that's the unfortunate fact. And what may happen in the future, of course, we don't know, do we?
No. I mean, none of us can see the future. No. I would have thought, but as I say, there are indications and there are reasons to believe that situation will improve. I believe, and moreover, obviously, this is not a point that has been taken in terms of the accessibility or sustainability of the scheme, between the council and the appellant.
No, I quite agree with you, it hasn't, and I'm not taking it in that context. I'm merely picking up a point made in your evidence, indicating to the inspector and also to those who are may be interested in the present position.
Understand.
4.8. Now, 4.7 and 4.8, in fact, it's a small point about the plans, but I want to get it clear. You're talking about the amended plans and the parameter plans, I think, which show viewing corridors. And you say, 4.8, they are inherently illustrative, etc. Now, I just want to be clear about this. The viewing corridors are put forward as an advantage of the scheme, in other words, preserving views in particular of the Grade 1 listed church. But if they are inherently illustrative, then the problem with that is that they may not survive. So do you agree with me that insofar as we've got viewing corridors shown in the parameter plans, that these will have to be the subject of a condition so that the viewing corridors are preserved?
I'm afraid I don't wholly agree, but I can probably qualify that paragraph. Those plans are illustrative in as much as A, they illustrate how those views can and will be created through further reserve matters. They are also illustrative in as much as plainly they are not fit for building from plans, as one would expect for a reserve matters application. believe weight can be given to those plans on that basis. But in terms of condition, I don't see the necessity for a bespoke condition for that. However, it is a matter agreed between the council and appellant that a general accordance condition would be an appropriate way of dealing with those, and quite clearly, significant deviation from any of the information shown on those plans, including those indicative view corridors,
Yes.
would not satisfy that condition. So I think the inspector can take that reassurance in terms of those details following through to reserve matters.
So, yes, I see. So it would move through to reserve matters on the basis of general conformity with listed plans, and then when reserve matters came forward, the appellant would, in principle anyway, would not be resisting a more detailed, if you will, condition setting out what the viewing corridors should be when the precise alignment of the houses had been agreed.
No, quite. I mean, it would be anticipated the reserve matters details on layout would be a refinement of those details as opposed to a departure.
Thank you very much. That's helpful. Don't think I need to ask you that in the circumstances. We've dealt with that. Yes, I mean, just let me ask you about, I'm sorry, I think it's page 47 of your, yes, I mean, you set out a helpful table there of harms and benefits. I mean, I'm not going to ask you about the detail of landscape harm or the detail of heritage harm and so on and so forth. Quite inappropriate. But just want your help with this. I can quite see that the I'm slightly puzzled. Construction employment and local spend, you don't appear to give particular weight to, or is my eyesight so bad that I'm missing some of the coloured
I'm afraid that may be right, although I have printed mine again in black and white, so it's a little bit faint on mine, but I do have moderate weight in the weight column on that summary table.
So what weight do you give to construction employment and local spend?
Moderate weight in both respects, yeah.
Thank you. See, the question I have for you really is this. When you're talking about construction employment and local spend, as far as construction employment is concerned, the spend from that will happen wherever the development takes place. So it doesn't have to take place in Wrington. If it took place better in Yatton, for the sake of argument, or whatever else it might be, then you get the spend in Yatton. So it's a bit difficult, really, isn't it, to attribute weight to the construction spend?
To construction employment?
Employment, I'm so sorry.
I feel that it's an inevitable consequence of development. It would be the same wherever those construction employees were employed, but the fact is that it is here. I'd say there's no real distinction to draw a comparison with saying that, well, you'd still have affordable housing being delivered wherever that affordable housing was being delivered, and therefore there's no need to give that particular weight here. I think the fact remains that there is a need for these things, and that there would be a benefit then derived from them arising from this development proceeding.
When you say local spend, do you mean local spend from the people who come to build the houses, or is it something different?
I mean the long-term local spend by the incoming residents, so that would be the long-term economic side of the coin as opposed to the construction being the short-term.
Okay, thank you. When you say, sorry, it really is extraordinarily difficult. It maybe is light. Provision of play facilities and provision of public open space, public realms. Significant weight you give to the POS. Provision of play facilities, what weight do you give to those?
That's another moderate weight.
Moderate, thank you very much. But play facilities, are there to cater for the development and to cater for those in the development. So they'd have to be there, wouldn't they? Otherwise it would be a bad development.
Yes, I can explain that, I can qualify that distinction between significant weight to the public open space and moderate weight to the play facilities, if that would assist, and it is partially that exact distinction that the provision of the play is, as you say, a policy on requirement. It is nonetheless a benefit and wouldn't be ring-fenced for the benefit of residents themselves, and I think it was accepted back on Friday that there would be some wider attraction to those living nearby, you know, particularly in the neighbouring estates, you know, a lot of which is, you know, family type housing, you know, to utilise those facilities. So I think they would contribute to the sustainability and amenity of the settlement more widely, and therefore have a positive weight in the balance. In terms of the significant weight to the public open space, we are looking at a kind of an above compliant level of open space, and I believe together with the Appeal B proposals, a very well connected degree of open space that would in turn connect to the wider walking routes and recreational routes that we've obviously heard evidence and indeed submissions by third parties about how valued those things are.
So are you sticking by moderate weight for the provision of play facilities?
I am, yes.
I see. So despite the... All right, never mind. I put the point to you. I'm not going to labour it. Let's just deal with the new public views of the church and the provision of a public open space, public realm, because we were told by Miss Armstrong about the public open space in the northeast part of the site from which you'll be able to see the church. And you give moderate weight to that, and you give significant weight to the public open space because you say other people will be able to access it apart from people on the development.
Yes.
Okay, right, understand that. Don't agree with you, but understand that. I'm not going to debate it with you. But moderate weight, new public views of the church. I mean, we've got no photo montages, we've got no viewpoint photographs showing what the view would be, how obstructed or otherwise it would be, and so on. It's something to which it's very difficult to attribute any weight at all, isn't it, in the absence of something like that?
Firstly, I don't disagree that there aren't any photo montages and so on to indicate how that would be achieved. However, and obviously we'll see this out on site tomorrow, one compares that layout parameter plan and particularly the view corridor, which is kind of a helpful reference point if one proceeds further north. We've obviously heard from the Rule 6 party in particular how the land rises to a point in the northern part of the site, and I think it will be apparent from the site visit tomorrow how increasingly visible the upper parts of the church tower are from that position. The inspector will see that for himself. In my view, having visited the site, I can quite readily see how those views would be achieved, and therefore feel it's fair to ascribe a nominal amount of weight to them. Fine.
Well, in that case, the inspector can, from your point of view, the inspector can note down that as a particular viewpoint to visit, but we will need to know, won't we, with a fair degree of exactitude, where it is likely that public open space will go.
I'd certainly endorse that approach. It's well worth our calibrating exactly where we're standing at the time.
Yeah, okay. Well, that'll have to be, I hope, a matter of agreement. So perhaps you could make a note that that is something that will have to be discussed with the local authority. Yes?
Yes, absolutely fine.
Thank you very much indeed. Just one moment. No, thanks very much indeed.
Thank you.
Mr. Storer, are you, do you need a moment just to go through your notes, or I've said this before, I'll say it again. I imagine it must be quite difficult following another advocate once they've done their cross-examination. So if you need a moment or two just to go through your list of questions, feel free.
So I was going to go on regardless, minding the time. Most of the PLA I'm quite happy Mr. Wardley Waterley has covered the points that we need, there's maybe a couple of others, but otherwise I was just going to go on to Appeal B mostly in this matter, which if that suits everybody, and Mr. Marsh is happy to continue, obviously.
Okay, yeah, fire away, please.
Thanks, sir. Mr. Marsh, just because I've got this table up in front of me on the Appeal A, so I was just going to finish off a question that's I've noticed. So I'm still referring to the planning benefits. So it is the Statement of Common Ground with the Council, which isn't our document at all, but I'm curious. Provision of affordable housing is at 30%, is that right?
That's correct, yes.
Yes. So I looked at the figures, and your table it describes the breakdown of 1 bed, 2 bed, 3 bed, 4 bed. Is that correct? I saw it initially in your design and access statement, or the design and access statement, but version 6, but I assume it's the same and hasn't changed. Is that right?
I'll have to draw that up, but it should be reflected in the latest design and access statement that accompanied the revised post-determination parameter plans, if that's where we're both going to be looking.
If you have a document called document number, but I suspect it hasn't changed.
Yes, it'd be very helpful if you did have that number to hand. I will have a look here as well.
Yeah.
D19, thank you.
Sorry, I missed that. Thank you very much, thank you. Oh, yes, so that is the same, yes, it's the same document, that D19. Thank you very much.
So you're looking at page 46 of that document, is that correct? Foot of page
yes,
46?
That's correct. Excellent. And it has a table there, and it sets out 1 bed, affordable 10, 19%, open market 4, 9%, reading across the top line. Does that match your figures there?
Yes, I see that, yeah.
Okay. So if you put these into context, that the total number of affordable dwellings comes out at 18, is that correct?
Yes.
And you've shown 30%, which is a rounding up from the 29.5082% of it. And then you come to the open market is 43, and that comes out at 70.49. 18 for the 4 decimal points. So I'm not disputing that, but just an interesting fact is that when you look at those, is the number of bedrooms that actually are provided in your assessment. I take it that, you may want to take some time to look at this or come back on this, but it's because the majority are 1-bedroomed houses, and if we take it that 1 bedroom would, on the basis of a bedroom equals a person, but that then comes down to just 19% or 19.37% of the available bedrooms, possibly people, and the open market then leaps up to 80% of the dwellings. So I mention it just because the 30% doesn't really represent 30% of the houses or dwellings, does it? It's all the ones that you're offering tend to be on the smaller scale. Would that be accurate?
Yes, I'm not sure I follow the mathematics entirely. I mean, typically a 1-bed unit, you'd be looking at a 2-person household, but I will acknowledge that owing primarily to the generally more pronounced need for smaller affordable units, there is a greater shift towards the smaller end with the affordable mix, and obviously that's something that gets developed in consultation with the local planning authorities, the local authorities' housing officers, in terms of what mix they would like to see based on their established need.
Yeah, absolutely. But I think the positive, what I'm trying to get is that it's where it's, you know, the weight that you give it, substantial positive weight. Well, you know, we've just established it's fairly qualified on exactly how much, you know, what is it, 30%, 20% of available dwelling space, if you want to put it that way.
Well, I mean, I think it's one of those things that it would not be acceptable from the local planning or authority's perspective, and would not make it through to a Section 106, quite frankly, that they'd be willing to sign if it prescribed something that wasn't aligned to the housing mix that they would like to see that reflects the local need. And because it does reflect the local need, it's reasonable in my view to afford it substantial harm, not least in the context that obviously provision of affordable housing continues to fall behind the already suboptimal delivery of market housing in North Somerset, amidst a admittedly national picture of underdelivery of affordable housing, and that's what leads to that conclusion on substantial weight.
I think my point that I'm just highlighting really is that the 30% headline figure is very commendable, but when you actually break it down, the actual space for people who would like affordable housing, and that means families and need some sort of housing, won't be getting that 30% of your proposed development. They're getting 20% of your proposed development.
They will be getting 30% of the dwellings that will be.
But this is the smaller end. Yes, I take the point that it's you can argue how many people go into each room, etc. But it's just drawing attention. And if we're talking about the positive, significant weights of such developments, it's just a question of how much that is actually worth, given that it's not the 30%. But I've raised it, and you're saying that you're sticking with your 30%?
Yes, I hope I've explained my reasoning on that point.
Thank you. So moving on to the Appeal B, Westwood Close. Your position seems to be that you've appealed the decision because the council didn't come back with a decision, but you're not overly concerned whether it goes ahead or not. Is that a fair assessment of your position, given what I've seen written down?
I can clarify that position. Hopefully this will help. In our view, it is a benefit of the development. Clearly in accessibility and design terms, connectivity terms, it provides another opportunity to connect to the amenities of the village, and is a positive thing. We wouldn't want the proposal considered without it. At the same time, you'll have probably seen in the schedule of conditions at the back of the Statement of Common Ground with the Council that my colleague has clarified the reasons for not agreeing with that conditions inclusion on the basis of obviously delivery of that link prior to occupation, simply because of the strict interpretation of the tests and the framework on necessity. Is that provision necessary to make the development acceptable in planning terms? The council feel that it is. We feel that it isn't. That's probably the largest degree of conflict is really on that condition, because we all agree that it is a good thing in and of itself, and it's something that, you know, the developer would be committed to delivering in any event.
And yes, I mean, so as you say, it was picked up by the Design West Review panel, I believe, wasn't it? This issue about the lack of connectivity.
Yeah, that's correct. Yeah, and I think that tells its own story, and it shows the the value of that process, I believe.
And yet you're still saying that it's not essential.
Yeah, that's correct. Yeah, the appeal A doesn't live or die on the outcome of appeal B, but it's clearly a beneficial addition with a clear value to the scheme.
Right. Right. So, looking at the plans that you've put forward, because obviously this was made 18 months after the original, and last Friday morning we received the rights of easement. So I'm going to just draw some time just looking at this, and I'm looking at the what have we got? Right of easement, easement right of way, works in respect of land at Wrington, and it's signed between Briony Smith and Christian Michael Joyce, and the other parties are the Garrett brothers. So I've got this one. Have you got a copy of that?
Can we just, Mr. Story, it's just being handed up, I think, to the witness, because he doesn't have...
Yeah, I'm afraid I don't have it to hand.
My apologies, thank you.
Which one was it again? You said the Joyce easement?
Yes, the one between Mr. Joyce, for simplicity, and the Garrett brothers.
Okay, and do you have a specific drawing? Because I don't have it in front of me. I'm just taking a note of it through.
Yes, trying to find a reference. So on this one, P19-2039-001. It's the same map that I referenced with Mr. Jones earlier. In fact, if that helps. Have you got it? Sorry.
I'm afraid I don't have a copy. I
sorry.
only have the,
My apologies.
unless it is included within this one. It's all right. All right. Thank you. Okay. There's an extra there. Thank you. Okay, we're set.
Yes.
Yeah, not paper handling.
You have it right, thank you. So, on your outline plan at the back, this large A3 size document, it shows that there is a section, and it is the same point that you would have heard me raise with Mr. Jones. The remaining lane to be left as existing condition, and it's this rectangle that is immediately as you would come away from the footpath from the appeal site and into this into the lane. And I did reference the photograph, if that helps you with the with Mr. Jones. Does that assist you at all?
Yes, I do recall. In fact, I may still have it on here.
Yeah.
We're looking at photo 3 of...
That's, I would go with photo number 5. Is a closer view of the piece of land, pretty much, that we are looking at.
Yes, I have it, thank you.
Yeah, okay. So, Mr. Jones was under the impression that all this bit of land that you could see in there would be sealed, up to the point of where you come off the still unsighted bit of pathway, because it's not visible from this, this part, but basically onto the track that you can see that leads up to the piggeries, and then would come around, and that would all be sealed you know, up to and including the point that this photograph is taken from. So that was what's proposed, that's what's gone in, that's what Mr. Clark has said that he can provide, and yet we have this plan that says, well, actually, if you draw a line from left to right, for sake of across this photograph, from the corner of the fencing, basically across to the track or the grass verge on the right, that bit stretching back for what, 20 feet maybe, won't be surfaced. Have I got that right from this plan?
I think from this plan, we don't have. We do have an annotation, but I do believe we have a condition in the agreed list at the back of the statement of common ground in relation to surfacing.
Well, I mean, maybe it helps if you turn it over actually and look at what's actually recorded as SK01, but just on the reverse of that large map. There's a red rectangle marked, and it's got, again, very clearly, remaining lane to be left as existing condition. But on previous plans I've seen, that's all meant to be surfaced. Is there any explanation for it, please?
I think so. It might help if I jump in at this point rather than the witness. I'm going to see if I can assist Mr. Storer. And if necessary, we can deal with it as part of the condition session as well. Mr. Storer, you recall Mr. Jones's evidence when you asked him about this?
Yes.
That the from the original scheme, the proposal has moved on somewhat, such that it is now expected that at the detail stage, that is when the conditions are discharged, all that land in question will be sealed with the bounded gravel. Do you remember him saying that? Because that's a requirement of the Highways Authority. All Plan 1 is doing is identifying the red line of the land, which this document refers to, and the rights are those set out at Schedule 1 in respect of that land. So it would be wrong to take the notations on the plan as being referable to the rights being granted. It's just. I mean, I have to say I'm going to apologise on behalf of the appellants for what is obviously the confusion that's arisen. It might have been much nicer to use a nice clean plan with no annotations just to show the area, but that's not what's been done. And so I'm sorry if that's led to you to be concerned that the rights don't extend to the resurfacing of that path, because they do. I hope that helps.
As you say, it's obviously caused some confusion, but if you're saying that it will be surfaced, despite it being marked that it won't be, then obviously then it would fail the condition.
Just to clarify, it's condition 2, and I must admit I don't have the very latest, as circulated last night, list of conditions, but I understand that the substance of that condition will remain the same, which is to say that it will be a matter of approval with the local authority, the surfacing of whatever needs surfacing to facilitate that.
No, I can readily understand the confusion, Mr. Storer, which is why I express the apologies that I do. But just so you don't misunderstand the document is identifying the land on which the rights are being granted. And those rights are set out at Schedule 1, which you'll see Schedule 1.1 includes the surfacing and maintaining.
Okay. Well, thank you for clarifying that. So, just moving on slightly then to the and we've heard this, there's shall we say, a alternative view to the ownership of the hedge in Westwood Close. And we heard from Mr. Gallop that he would, that he was basically, considers that he's adopted the hedge because he's the one who's maintained it. And yet Mr. Clark has said, although he has no title to it, is laying claim to it. Can you clarify that for myself, the villagers and the inspector, please?
I mean, put simply, my understanding is that that Mr. Clark has claimed ownership of that and has, obviously, you'll see from the documents before you, provided for relevant works and visibility displays to be provided over that land. I must admit, I am not overly familiar with the legal implications of maintaining hedges over time, but based on what's in front of me, I would be satisfied that what's being proposed is deliverable in the planning sense, and that the documents provided to the inspector are hopefully clear in that respect.
I mean, because I referenced earlier this morning, and I haven't produced it because there was some doubt about it, but if I'm just trying to find the relevant document, because you say they do keep changing. Yes, it is. Right. So this document is deed of easement brackets Clark. I'm afraid I don't have a document, but it is one of your documents. I don't know whether somebody could assist you. This,
I think is that the one I have before me, dated the 14th of June?
That's correct, yes.
Yes.
Okay. So, if we look at, trying to find the, I thought we had one. In fact, I thought we had a better. Oh, there we are. And in fact, he says, I've clicked on the wrong one. What's this? Footpath link ownership statement. Maybe that's the June 2022. Maybe that might help slightly better. I thought the one I was looking at was the original one with Mr. Clark. But you've got an earlier one that has the red track that leads up to the piggeries, which isn't in dispute. And then you have a copy of the 1963 conveyancing. And
yes, is that
then,
is that Appendix 2?
And it was the document on page 19 that I mentioned earlier that I'd superimposed, but I'm sure that we can solve this without too many issues. If you look at the map, for sake of argument, on page 23, you will see that the red outline.
Sorry, Mr. Storer, I'm not sure. Page 23 of what?
Oh, sorry, sir. It's the document Footpath Link Ownership Statement, June 2022. And yes, page 23.
Yeah, got it. Thank you.
Okay, sorry, sir. I was. So the red shading, there's a red line, and I think we've now established that the small parallelogram, in that left-hand side, is the land that the Mr. Joyce is now saying that he's given you granted rights away, and the width of that doesn't match the width of the large shaded yellow area that Mr. Clark now claims. And the significance, if I just jump to the point that I'm trying to make, is that the original track and the original bit as referenced by Mr. Gallop is that there was always a 2-foot verge between that track and the Westward Close, and that's the land that the hedge sits on. Can you see what I'm trying to point out? And so, if you extended the line of that small red line that runs east-west, and you extend it down the unmade track in an easterly direction, it would leave a significant gap between the property of Mrs. Edgar and your proposed footway.
I think I follow where we're looking. My understanding is that either the land, or rather neither the land to the south of that hatched area on that kind of intervening verge, let's say, and I think we did go through this in evidence, if I recall, whether or not including that, we wouldn't be reliant upon that to achieve the footway itself or the visibility splays that are being shown. So where or not that boundary actually lies, I think of the two scenarios described, wouldn't materially affect the ability to deliver that footway link, would be my inference and understanding from the information that I've got in front of me.
So my point is that if you then turn to page 10 and you see the dotted line, the dotted line extends east-west along the unmade track, and there is a clear space between the other dotted line that marks the edge of Westward Close. And the most northerly dotted line is distinctly separate from the boundary of number 7 Westward Close. Can you see that?
Yes, I can see that. Obviously this is applied on an OS base, and I think reflects those other details in terms of kind of broad alignments of boundary features and such.
I've drawn it to attention and comment, and it will no doubt be discussed tomorrow on the site visit, but just so that we understand, and we've all seen this map, that our contention is that the track that you could grant, or Mr. Clark could grant right of way on, does not include the hedge, because he has got no sort of claim of ownership. He's never touched it. He might have driven up and down the track, but there's no suggestion that he's ever maintained the hedge that was put in by Victor Sproul, as evidenced by Mr. Gallop when he addressed the inspector on Wednesday. Would that be correct?
Well, I understand there's a claim of ownership of the track along there. As I say, as regards any maintenance, I would be none the wiser. I'm afraid I can't really assist you in that respect. But and I appreciate this is probably not giving you the most assistance in terms of the question that you're asking. But as I've said, I don't see anything on the basis of the information before me that would suggest that there is any issue in terms of the deliverability of that link, and I think that is fundamentally the only matter really for the inspector's consideration arising from this material. Okay.
I mean, I intend to just deal with on the site visit tomorrow, sir, if that will just assist.
Well, to be absolutely clear, there won't be a discussion on the site visit. If you want to draw things to my attention as matters of fact, like there's the hedge, sir, that's absolutely fine. What I can't hear is views and opinion on gaps and hedges and that sort of thing. It's pure the site visit is exclusively for me to see things, not to hear evidence.
No.
So if there's a question you wish to point to be made that is pursuant to this, it's now, or if it's a conditional matter, which it may be, it's perhaps something that can be dealt with in the session that's to come this afternoon. But please don't leave anything over to the site visit that you want to deal with now, is my point.
Thank you, sir. That does clarify. I mean, yes. So having been involved in this application, Mr. Marsh, for some time, this hasn't come up. It's not been something that's been discussed about the practicalities of actually complying with the highways conditions as sort of put forward.
Well, it was a question that was raised by the council following the appeal against non-determination of that application, and as I understand it, there wasn't a great degree of discussion prior to that point. However, subsequent discussions have confirmed that the local highways authority has no issue with the deliverability and suitability of that link. The local planning authority has no issue with the suitability and deliverability of that link. And as a result, that's why we have the pre-occupation condition as it is worded, and I hope I've explained, you know, the reason for the divergence in view on the necessity for that condition. But I mean, the fundamental underpinnings in terms of what it would achieve are not a matter in dispute between the appellant and the council. So in short, that deliverability has been explored, I would say, between the appeal parties, and you know, we are, I believe, in agreement that there wouldn't be any issue as regards its deliverability.
And I'm obviously something that would have to be discussed about the council being able to cut through a hedge if they don't own it. I take it that they can trim it as if it's adopted, but if the ownership is disputed and you don't have rights of way, in your experience, would a council cut through a hedge?
I can't foresee a situation in which the council would intervene in a hedge on anybody else's property, but I understand they do have rights to maintain anything that is ingressing on their own adopted areas. But that's obviously not to say that it wouldn't continue to exist and serve its normal function. Yeah, as regards what that maintenance schedule might be, I couldn't say, because it would fall to presumably the local highway authority.
Right. Okay. I'm sure that if there is a question of ownership, then, as you say, I'll put it to you, I think, as simply as possible, that given the claim by Mr. Gallop and that Mr. Clark just does not have ownership of that hedge and cannot grant you rights of way through it.
Well, I can't dispute that that's the assertion of Mr. Gallop. As I say, I have to take account of the evidence that's before me, and that points to the outcome, or the understanding which I think is agreed with the council, that that the control of the land is as in front of us, and that the footway is deliverable.
Right. But okay. Just on another question, that you make reference about the proposed cycleway that would link the old railway to the Strawberry line. Can you give any indication if that's actually feasible or not, or even likely to be happening in the next, the foreseeable future?
Of course, clearly it isn't there now. However, it was, I believe, a safeguarded route in the previous local plan. It is a safeguarded route in the current local plan, and as I understand it, there is absolutely no intention on the part of the council not to include it in their forthcoming 2038 plan as a safeguarded route. I think it would be agreed by all parties that it's a very positive thing. On the face of it, I don't see any reason why it should not be achievable, and I would suspect that the council would have had full regard to the achievability of it in including it within their plan. It would be a little daft and remiss not to do so.
So a laudable aim, but it hasn't been put forward as a realistic proposition. Would that be correct?
I would say it's been put forward as a realistic proposition in as much as it has passed the tests of inclusion within the development plan. It clearly is something that is down to others to ensure the implementation of, and I agree, a laudable aim. Again, on the basis of what I see before me, I see no reason why it shouldn't be achievable.
And just to finish this, but you're not making any contribution towards the cost that this might entail to do so?
No, that's correct. There's been no request from the planning authority for contributions in that respect, and therefore we've, as we'll hear later on, signed up to heads of terms pursuant to the SIL regulations and the requests of the council.
Okay, thank you. And I'm just, and the inspector may bear with me, and if this is not an appropriate moment to bring it up, but it's to do with the a point raised by a couple of people in the Memorial Hall about the future of the land, marked as J2 and described by Wardle Armstrong as being highly sensitive because there was nothing to stop any further expansion westwards. Do you remember have I remembered it correctly? Okay, sorry, I will...
Rather than shout, I could use the microphone. Sorry, I'd be grateful if you could direct me to the relevant document.
I will just...
J2 annotation.
Let me... It's one of these I think I've managed to close, so I do apologise.
Was this in the landscape document?
Yeah, I think you're talking about the landscape character.
Yes,
area.
sorry, yes, it was Wardle Armstrong was being referenced because they regarded the site as highly sensitive, and Mr. Liais was saying that it was less than that it wasn't only moderate because it was it abutted the settlement. I mean, I reference it because maybe you don't need to see it, but Mr. Liais was very key. It was quick to point out that by reinstating the hedge on the western boundary, he considered that would be would contain the site, and it would any further concerns wouldn't be justified. Is that something that sounds familiar to if I...
Yes, I mean, I recall the broad gist of the evidence given at the time. That yes, I think it was the question over the absence or otherwise of any robust landscape features that would contain the development. Obviously, landscape matters go well beyond my expertise, such as it is.
Okay. And the reason why I mentioned that is that on the outline plan, there is the road runs in, and then it was described as a hammerhead, I believe, where the road splits or has a junction, and the right-hand or eastbound side of the track would give access into the paddock where future development was shown. Does that sound, are you familiar with that part of the plans?
Again, it would be helpful to have reference to a plan, or shall I mean, I can pull up the master plan if that would be a suitable point of reference.
I've got the illustrative master plan,
Yeah,
and it is just come off core documents. It's unhelpful. It doesn't have the on the tab. It doesn't tell me which one it is.
Okay, I mean, I've got C5.5 here, which is the July 2021 master plan. That's, I think, probably for our present purposes. Obviously, it doesn't reflect the latest tweaks. D6.
Yes, I will.
Retard.
And yes, it's marked drawing 0701-1003, August 2020 is the date. So just on that, so you have this, there's a purple circle in the middle. Are we looking at the same document?
Just dragging it onto the screen, just taking its sweet time. Right, yes, I've got that drawing in front of me now.
So you have the what is the dotted purple with a spot in it, and it's shown on the key as key node point of arrival.
Yes.
Yes. So the one of the plans it shows that you could break through and go into the paddock, and then on the other arm it goes westwards and then splits and runs along the houses. And there's a green interactive play opportunity in front of you.
Yes.
Okay. So my point is that this main street has a secondary street, which then runs north-south, and that would then, according to Mr. Liais, come up against the hedge. You'd have the hedge boundary. So I appreciate this is outside the site, but it has raised concerns amongst the villagers, and that is that and I referenced them this morning with the inspector about the plans that had been provided by by yourselves that showed how much land the appellant or the developer has actually extended the original title by. Would it assist if I gave you a copy of this?
I think I've seen it. I mean, if you're referring to the extent of the land ownership, I believe the Clark's land ownership, as I understand it, the appellant doesn't have control of anything beyond the areas subject of the current appeals. And I think in terms of, first, the role of that westerly hedgerow, as I understand it, the Clark ownership does extend beyond that, but I recall Mr. Liais' evidence obviously focused on the point that just as that degree of containment is of assistance in ensuring that there isn't a significant adverse wider landscape impact, going beyond that would throw us into very different territory because the landscape becomes characteristically much more open. As I say, I don't want to veer into detailed landscape discussion because that wouldn't be appropriate, but judging the proposals as they are before us, today and without anything else on the table for consideration or indeed in immediate prospect, quite clearly there are different considerations that would apply to anything beyond that, and I think it was a matter accepted by Mr. Lier that you're looking at a very different landscape context the moment you go beyond that westerly hedgerow boundary.
But if you applied Mr. Lier's definition of what was highly sensitive or merely moderate, he said that anything that was against a village boundary reduced in value to moderate. And if you take that to its sort of logical conclusion, it would mean that in the future, a developer could come along and say, we are only going to develop this bit of land that's adjacent to the bit of land that was developed previously. Which is,
If I may, I'm going to interfere because there wasn't actually Mr. Lee's answer, if you'll forgive me. He said you'll have your note, but he was very careful. He said two things. One, you'll always have to take into account in judging sensitivity the fact it's against a settlement boundary, but how it reads depends on the settlement boundary. And he made a distinction between the settlement boundary that we currently have, which he described as being stark, and the settlement boundary as it would be with the proposal in place and the proposed western hedge and landscaping. So it would be not safe to read anything further than that going westwards.
Well,
I think Mr. Boyle has beat me to it there.
I've got a note of what Mr. Lier said. I'd also, I'm not going to cut off this line of questioning, but I would remind you that all I'll be determining is what's in front of me, and well, I can't look beyond the red line because there's nothing proposed beyond the red line. So that's as far as my ability to determine things goes, and of course we don't know what will happen in the future, but that's all I'll be looking at when I make my decision.
Okay. Yes, thank you very much, sir. Yes, I appreciate that. And this will be my final point because I raised it the other day, and I'm still curious. If you bear with me, sir, it was the bit of land that I referred to as the red cutout, which caused confusion, but it's the southernmost boundary that runs along the Yeo and is in a sort of straight line rectangular extension of the site. I asked Mr. Jones, and because I thought it was where the excess water was going to drain, and obviously there is a pipe or existing that runs through it, but it just seems much larger than that. Do you know, is it something that you're familiar with from the plans?
Yes, so we're looking at the sort of irregular chunk in the southernmost extent of the red line.
Yes.
Yeah, I hopefully can clarify on that front. It does have to do with the surface water strategy, and it is in order to retain flexibility for the eventual location of the surface water outfall in the southern part of the site. So rather than being constrained to a specific linear route, it's to allow for that technical strategy to inform the best possible outfall location within the bounds of the red line that we've got. So it's simply for that purpose, but it doesn't mean that the actual physical infrastructure is going to be any bigger than it otherwise would be.
No, I mean, it's in the floodplain, so you'd be constrained for building, and it sort of comes back to the point we were making at the time that you're going to try and you're draining very successfully, according to Mr. Strudley, that you will be able to drain the attenuation basin into the flooded water, but as I said at the time, I'm sure that will be sorted out in the final figures. And I think we were agreed, or Mr. Strudley said that, and I think you have already said earlier on, that the general layout of this is merely illustrative, and things like the attenuation basin could well move as required.
I mean, there are some general parameters. I think Mr. Studley's point was that the attenuation basin, as shown currently, the kind of broad location dimensions that are actually informed by something, namely topography and the capacity that is estimated, albeit on a kind of conservative, if you like, worst case kind of basis to ensure that there isn't any kind of further significant enlargement of that in practice. So yes, there is some degree of flexibility and it is subject to final technical design, but what's there is, for want of a better term, sensible.
Okay. Thank you, sir. Thank you.
Thank you. Is there much by way of re-examination, Mr. Boyle?
No, sir. I think if you're happy, I just prefer to crash on, unless, of course, you have significant questions.
No, I don't. I'm always mindful of the witness. Are you happy to press on? Okay, let's do that then, Mr. Boyle.
Mr. Marsh, you're okay? Yeah, it won't be very long. Let me just pick up one point from Mr. Sutley's, Mr. Storer's questions to you. Do you remember you looked at the footpath link ownership document?
Yes.
And you were looking at the, I didn't have page numbers in my version, but I've got a handwritten, inverted commas, CSC2, which I think was the page you were being directed to. It's the one that shows the yellow cross-hatching, which Mr. Clark was giving rights over. It looks like that.
Thank you. Yes, yeah,
Yeah.
that.
So do you have that? I think this was the plan that was being referred to, but if not, it certainly shows what I need it to show. Well, that's,
Yes, I hope it was. 'Cause I was looking at
that's a
it.
comfort, I must say.
Yes, it's certainly the one I was looking at, but now I'm struggling to re-find it.
It seems to be Appendix 3.
Appendix 3.
And there are two plans. It's the second to those, CSC2.
I've got it.
Oh, yes.
Thank you.
You got it?
Yeah.
It's after the
I just
statutory
yeah.
declaration of Mr. Clark. It's this. I hope it's simple. Do you see the grey notation? On Westwood Close,
Oh, yes, yes.
the grey notation, and it says approximate extent of adopted highway, and you see it runs up to the solid line and embraces the pecked line.
Yes.
Now, as I understand the proposition of Mr. Gallop, and now extended to the inquiry by Mr. Storer, there's a private law ownership dispute, or there may be a private law ownership dispute between Mr. Clark and Mr. Gallop as to whether or not some or all of that hedge that lies between the pecked line and the solid line belongs to one or the other of them.
Yes.
As far as the Highways Authority is concerned, what do they say in terms of that hedge lying within the adopted highway or outside the adopted highway?
Well, I believe they said that it's within it.
Yeah, and if we've got, do you have the Highway Statement of Common Ground to hand?
I do, yes. Yes, conveniently right here.
Do you have that? We looked at this earlier in the inquiry. There's a drawing which is Appendix Stroke G, which is an extract from the definitive map. And it's got the highway in different categories. Again, I don't have it.
Yes, I have that.
Got it? And you see the green notation, Westwood Close. Class 4, unclassified road.
Yes, see that.
Yeah. So, regardless of who owns it in private law, to what extent do these plans indicate that the Highways Authority have highways rights over it?
Well, these would indicate that, yeah, that the Highways Authority controls and has unfettered rights over that.
Thank you. And so in terms of the ability to undertake the works, which after all are to provide for a public right-of-way, which will then be adopted as public highway by the Highways Authority. Can you assist, Inspector, with whether the private ownership dispute, if indeed there is one, affects that situation?
Well, I don't believe it does in this instance. I think the evidence is clear.
Thank you very much. You can put that away. Okay. Thank you. Now, I think there were just two points. The cross-examination and friend, Mr. Wadsley. Although they became themes, so forgive me if I have to pick it up thematically. The first is this. Do you remember you were challenged about bus provision?
Yes.
Which reason for refusal does that direct itself to, of the two that we have before us?
I would struggle to answer that question, Mr. Boyle.
Can you assess whether it applies to either, in your view?
As I don't feel that it does apply to either the heritage or landscape reasons before us.
Thank you. Now, do you remember we looked at policy CS32 in your evidence in chief?
We did, yes.
And you asserted that there was no indication from the authority that they were now changing or challenging through this inquiry the status of Wrington as a service village.
No, that's my understanding.
Was it suggested through cross-examination that the authority would now like to challenge the status of Wrington as a service village?
I'm not sure it was expressed in absolute terms. It was more that there had been a depletion in services that altered the assessment of the appeals in a way that doesn't have regard to the fact that it remains a service village.
Thank you very much. Now, does CS32 distinguish between the service villages as to what might or might not be appropriate by way of the quantum of development either within or outside the settlement boundary?
No, it doesn't. I think that's a point that I did make in relation to the inspector's original report modifications.
And if villages of this nature are vulnerable to a decline in services over time as their population drops, what would CS32 seek to achieve in terms of the first paragraph before you get into the 7 criteria?
Well, if we look at that first paragraph, obviously the objective being to enhance the overall sustainability, and I think as I indicated earlier, those services are dependent on the patronage of the locals to ensure their viability, and to that end, an increase in population as appropriate would, in my view, improve the sustainability of those services and facilities.
Well, put it in a different direction. To what extent would it promote the aims sought to be promoted by CS32 by choking off additional development and hence population, and particularly population of a working age?
Well, I believe it would run contrary to that stated objective.
That's helpful. Now, specifically, remember you were asked about questions to do with cumulative impact and more broadly about the level of services available within Wrington. Yeah?
Yes.
We heard in the authorities' evidence objection bullets 1 and 4 to do with landscape and heritage.
Yes.
Bullet 3 and bullet 5, just remind yourself, if you don't mind, of what they cover. Bullet 3 to do with services and bullet 5 to do with cumulative effect.
Yes.
To what extent has the authority either articulated in a reason for refusal or articulated in evidence that there is breach of bullet 3 by reference to the level of services, or bullet 5 by reference to cumulative effects because of other development?
Well, in respect of 3 and 5, it hasn't at any stage. The council hasn't advanced a case in relation to 1 and 4, I believe, until the production of evidence, and it doesn't. Those criteria don't appear in the reasons for refusal. But in respect to 3 and 5, they've not advanced a case on the grounds of those.
Thank you. Thank you very much. Thank you, Mr. Marsh. Those were the only points.
Thank you.
Thank you, Mr. Marsh. That concludes the witnesses. We've just got the Section 106 and conditions session. I think perhaps we could all benefit from a short break to freshen up and sharpen our pencils on that front. As far as I know, I've still not got a copy of the latest iteration of the conditions, but it looks like somebody else has, so that's positive. Can we just give ourselves 10 minutes? We'll adjourn until 10 past, so we'll resume it at 10 past. We're adjourned. Thank you. Okay, it's now 10 past. The inquiry is resumed. In terms of which we do first, I suggest we deal with the legal agreement first, because that's the one I've got fewer things on. Bearing in mind what I said this morning, in terms of somebody helping out by explaining what their heads are, primarily for people who are watching in via the virtual link. You're Mr. Coombs, have I got that right?
Yes, sir.
Good afternoon. Am I right in saying that you're going to you've got that honour?
Yes, sir. I have a clean Grossman's copy of the Section 106 to pass to you. Also, for the conditions, I have a letter confirming agreement to pre-commencement conditions as well, as you requested.
Good. Well, I'll be handing those up whenever suits you, really. Thank you. So, in terms of the what I've just been handed up, it's a copy of the of the 106. Is this the same iteration that has already been distributed electronically?
Yes, sir. It should be the same version that was issued immediately prior to the inquiry opening.
I think that the date I've got in mind is the 14th of June, but there may have been a later one actually.
In which case, it may be a slightly later version with some minor revisions, sir.
Okay. Well, not to worry. I can look at that. Okay. Could you? The other point was the agreement regarding conditions. Have I got that right in terms of pre-commencement conditions? Yeah. Okay. Thank you. Right. Yeah. If you could just talk us through the 106, not absolutely, but just in terms of the what its obligations are and what they're seeking to achieve and why, please.
Yes, sir. Probably the easiest thing to do is to work through the first schedule, so it is, which is the affordable housing provision. There's some discussion in the evidence of Mr. Marsh and cross-examination from Mr. Storer about that. This simply details all the very extensive legal compliance elements in terms of delivering affordable housing. The key element that the Rule 6 party may be interested in is Table 1, which sets out the tenure mix. That's been requested by the Council's Affordable Housing Officer, and that is based on a published document on their housing mix requirements, and that sets out both the tenure split and the size of accommodation that we sought based on a percentage split, because whilst we're obviously applying for 61 dwellings, that is an outline scheme, and therefore there may be less than that, so it's not a hard number that is given, but a percentage split. Just for clarity, there's provision there within 2.5, which sets out that it's taken to the nearest whole number, so where it's less than 0.5, where it's greater than 0.5. Moving on to the second schedule, which provides the open space provisions. So the council have relevant policy references to various typologies of open space, which are secured through the agreement. And you'll see there the definitions. It includes open space land and sets out the relevant provisions there, which is based on the policy compliant position rather than what's set out within the appeal scheme. And you'll refer to Mr. Marsh's evidence where he discussed about there being provision in excess of that, but this is the policy compliant position, so that may well, that would be the baseline requirement for any reserved matters proposal. Within this schedule, there are provisions for how that is secured in terms of whether it is adopted by the local authority or whether it's dealt with through a private management company, and there are measures for ensuring that the cost of those, any adoption process is addressed for the council, and then if there is a private management company, that is then addressed by the developer and any subsequent private management company maintaining the open space provision perpetuity thereafter. The third schedule sets out the arrangement for a number of financial contributions, which are fixed sums. They are defined in the early stages of the agreement in terms of the definitions that cover the majority, but I'll simply list them out. So the first one is fire hydrant maintenance contribution, which is set out by the Fire Authority, requesting how many fire hydrants would be necessary for a scheme of this type. And that's defined as a contribution of £10,500. Then move on to the public transport contribution, which there's been some discussion obviously around bus provision, and there's £100,000 there set aside for enhancing public transport provision within the local community. Then moving on to school transport contribution, you may recall some discussion around this, and that's a contribution of £714,000, 590 and 89 pence towards school transport. And then there's the sustainable travel contribution, which is a provision of £120 per dwelling for incentive vouchers for public transport tickets, bikes, and various other paraphernalia, etc. Moving on to the fourth schedule, this is simply what binds the council to use the contributions sought by the Section 106 agreement to be used in an appropriate manner, and then if they are not utilised appropriately, to be paid back to the developer in the rare occasion that that were to occur. And that is the summation of the Section 106 agreement, sir.
Okay, thank you. There's one of these so-called blue pencil clauses in there as well earlier in the agreement. That's essentially that if I or the Secretary of State conclude that any of the obligations don't meet the tests, then they would not bite, so to speak. They'd fall away, or at least that's my understanding of the intention of the wording. I don't have anything on the legal agreement. As I said earlier, well, firstly, thank you for walking us through it. The Council's produced what I think is a helpful document. And certainly the version I've got is called Butts Batch Wrington Statements of Seal Compliance. And am I right in saying that's on the Council's website? And if anybody does want to read it, they can do that. I'm looking to the Council's team and I'm not getting any nods. I'm going to work on it. I'm getting one. That's a very positive nod. Thank you. I'm going to work on that assumption. But if it's not on there, if it could be added, but it looks like it is. So if anybody watching online is interested and wants to sort of have a more careful look at what the 106 is intending to do and why, and the Council's position on that, I think that's quite a good starting point. Are there any points on the legal agreement that anybody wanted to raise? Because, as I say, I don't have any, and if there aren't, I don't think there's any need for us to dwell on it. I'm not getting any, so let's just pause a moment, allow this conversation to conclude.
You may recall that at the session at Wrington, I mentioned one of the contributions which related to had resonance for had a resonance for school transport and travel and the like, and I said that would be explained, and Mr. Wilmot, who's here, would be able to deal with that briefly, I'm sure.
Well, please do. Not least for people who spoke and were attended on Wednesday of last week. Please do.
Thank you, sir. I believe that the matter of school places and capacity at the local school, local primary school, was raised earlier during the inquiry, and the school transport contribution in particular reflects that situation. The nearest secondary school lies beyond the statutory walking distance, so the local authority would have an obligation to provide school transport for that. But in this particular instance, there are no places remaining at the local primary school, and therefore, probably unusually, we've had to seek contributions towards the provision of transport to the nearest primary school with capacity for that. So those two combined to make the school transport contribution, which totalled just over £714,000.
Okay. Was there something else?
Just in terms of the public transport, again, I think you will have heard that the previous A5 service had ceased. We have managed to support a new service, the 51, which travels from Wrington to Weston and therefore provides connections to a range of employment opportunities, training and education, retail and leisure. That again reflects the figure of £100,000 reflects the significant cost of actually setting up, and particularly the early years of trying to establish a new public service for the village. As I say, that is also necessary to effectively to make sense of the support for sustainable travel measures, because clearly there's little point in providing incentives for people to travel by public transport if there is no service that remains in existence. So there is a strong relationship between the various heads of the agreement.
Thank you for that clarification. Can I just make a note of your name? Excuse me, I didn't... Yeah, I think I was sent a note before the inquiry that to expect you. So thank you for that, Mr. Wilmot. Was there anything else on 106 before we move on to conditions? No. Okay, we'll do that then. Move on to the conditions. I've not had a chance to look at what I've just been given yet, so I'm going to refer back to my earlier note that I shared with you on Friday, and I'm going to just go. Obviously, we've got two sets of conditions for Appeal A and Appeal B. Am I right in saying that Condition 1 hasn't changed since the version I saw earlier? I'm going to just go through these sequentially. Does anybody have a point on Condition 1?
I was just going to mention, sir, the version we've handed round in paper form to everybody in the room is formatted and marked up in colour where there have been changes.
Thank you.
So if there's no change shown, then no, they haven't.
That's
since
helpful,
last week.
because I would have just kept doing that, and you've saved me a lot of hot air. Let me just make a note of some of that. Bear with me, please. Okay, that's I can see how things have changed. That's helpful. Okay, well, I'm not going to dwell on things unnecessarily, so I'll step through these, and please wave your arms or shout out if you've got something on a condition. I didn't have anything through to Condition 5. Does anybody have anything on 1 to 4? No. Yeah, Condition 5 is sort of distance between the main parties on the necessity for 5. We just heard today, so it's pretty fresh in my memory what the appellant's position is on this, so I'm not going to invite you to repeat any of that. But I think it might be helpful, well, for everybody's sake, but certainly for my sake, if somebody from the council could explain to me why it considers Condition 5 is necessary, please.
Thank you. Well, I think you will have heard that local residents had indicated the difficulties of moving around Wrington and that that's not necessarily that easy for pedestrians and cyclists. I think in connection with this particular site, we felt that particularly for new residents, and particularly any that were at the top end of the site, that it is a far more convenient route to be able to go via Westwood Close, and that would actually encourage pedestrian and cycle movement as opposed to people getting in their car, because I think we feel that if you have to go walk or cycle southwards only to effectively retrace your steps to go northwards again to the village centre, that is a deterrent really to people moving and going about their business in a sustainable way that avoids the need for use of motor vehicles. And I think that we strongly felt that the policies contained within the core strategy policy 10, policy DM 24 of the Sites and Policies Plan Part 2, but also I think we hadn't specifically mentioned it, but DM 32 of the Sites and Policies Plan Part 1 all seem to strongly encourage.
Sorry, I was a bit slow there.
Sorry.
What was that last policy reference, please?
DM 32.
DM 32, thank you.
Which is, I think, probably more particularly a design-orientated policy about placemaking and developing convenient places to live. And I think we feel strongly that all of those are strong encouragements to try to do our best to ensure that sustainable travel opportunities are built in and are integral to the design of new estates.
Okay, thank you for that. Was there anything else from anyone on condition 5? No? Okay. We'll turn the page. Yeah, I didn't have anything on 6, 7 or 8, so unless anybody else wanted to talk about those, we can go straight to 9. This is one of the ones I flagged on Friday on a couple of points really. The frequency with which the term looks is used, and it looks, excuse me, I didn't intend that pun, but it appears that there's been a rationalisation. It now reads, prior to the installation of any lighting, including any residential plots, a site-wide lighting strategy expressed in lux level should be submitted to the local planning authority in writing. This shall show the light levels with details of, and then it continues as it did previously until Roman numeral 2, where lux is omitted and light levels replaces it, and then it looks like Roman 5 has been omitted. Have I got that right? As it previously appeared. Just looking around the room.
Yes, that's correct.
Yeah, sorry, for everybody's benefit, the previous Roman 5 read the hours of lighting operation shall be submitted to and approved in writing by the local planning authority. That was one of the things I queried yesterday. So that's just been omitted, has it? Have I got that right?
Sorry, no, just to clarify that, sorry, I was confused myself there. I think we've just failed to give it a separate line to itself, so 5 is actually still there.
I've got you. Oh, so it is, yeah. It's just sitting.
So I believe that may have been my issue in formatting when I compiled it into the table, so apologies.
Oh, well, it was me glazing over it and having to juggle glasses as well. I'm struggling with this font for some reason, so if you'll excuse me perching my glasses on my forehead. Okay, so Roman 5, I flagged, but we'll come back to that. And then the text below owes the adhered to point that I raised, and I really queried about retention. So the last line has changed, or you're proposing the last line changed to this lighting scheme should be implemented and no changes should be made to this without the prior approval of the local planning authority. Okay, I understand that. Okay, so I've got all of that. It was just going back to Roman numeral 5, the hours of lighting operation, which should be submitted to and approved in writing by the local planning authority. Obviously, this condition goes to, at least in part, protecting bats. What is the purpose of the hours aspect of the condition, and how reasonable a prospect is it, realistic a prospect is it that it will be, it can be enforced?
So just to clarify, it's fairly standard practice with modern lighting installations to have time controls as part of the installation. That's, to be honest, it's normally a standard provision of the Highway Authority as part of sort of cost-saving measures for adopted highways, as much as light pollution, which obviously we've heard about, as well as impacts upon protected species as well. And it normally involves turning off or turning lower the lighting installation during the small hours of the night. So that was my envisaging of what that alluded to.
So this part of the condition at least goes to highway lighting. It's not any other form of lighting.
Yes, I believe a reasonable interpretation of it when it came to discharging the condition would apply to elements that were within the control of the Highway Authority in that regard.
Excuse me, sir, sorry, if I may, I'm not quite sure where I sit in this, but the...
Well, you just I can help you on that. You're very welcome to contribute, so please don't hesitate.
It was purely to point out that if there is lighting controls, it might assist the neighbours, because this is behind the houses and a lot of the bedrooms are facing onto this lane. And yes, it would just, I think, assist, them get to sleep in the evening.
Okay, that's noted. Thank you. Just to be clear, from the council's point of view, was that the council's understanding also in terms of what Mr. Coombs just said, that this lighting is the intention is that it would be part of the highway lighting?
Yes, that would be my understanding, yes.
Okay, thank you. Right, anything else on condition 9 before we move on? No, okay, we will do that then. Condition 10 was one of the others I flagged on last week. That has changed. I sort of queried why there were two lists, really, and it looks like there's been quite a lot of change here. Rather than me trying to figure it out, could somebody tell me what's changed and why,
yes,
please?
So, yeah, mindful of the comments that you made about that, we sort of looked at that again. I'm not quite sure quite how that had arisen, but yes, there were effectively two lists. That's been rationalised effectively by trying to incorporate some of those things that were in the second list just into the first 7 points. So I think nothing has been omitted that probably would have been a controlling feature originally, but I think it's more concisely expressed now.
Okay, that's helpful. I'm just going, because I've only just seen these, I'm just going to take a moment to read them, so if everybody can bear with me, please. Okay, I've got that. Anybody else got anything on condition 10 before we move on? No. There was one small thing on condition 11. Okay, it's just that was just a note to myself more than anything else. So I didn't have anything substantive on 11. In which case, I didn't have anything until through to 14. Does anybody have anything on conditions through to 13? No. Okay, we'll go to 14. Has 14 changed? I don't.
It hasn't. It's my turn to apologise now for some formatting errors in the
Okay,
spirit
yeah,
of getting it done quickly.
That's all right. So these things happen. I think it. In fact, I didn't have anything substantive on this. It was really a note to myself to double check that that's the correct plan reference. That's all. So I think we can, unless anybody's desperate to talk about condition 14, I think we can move on to 16, because I didn't have anything on 15, and unless anybody else has, we can move on to 16. I didn't have much on 16. It was just, I think it was just my point about abbreviations that, well, terms that are abbreviated not really needing to be abbreviated. So I think that's a sort of a self-answering point. Is there any reason why 16's got FRA and AOND in there? I don't think either term crop up again, so to my mind they can probably be happily deleted. Absolutely tiny points in the scheme of things, but okay. 17 I didn't have anything on, and it doesn't appear to have changed, so I shall skip on to 18, which has been skipped entirely. This was me. I queried, is this a matter for the reserve matter stage? It's sort of implicit by its omission that it's been agreed that it is a matter for the reserve matter stage. Have I got that right?
That's correct. I mean, I think it is a condition requiring sample panels of materials. It's one that we frequently do apply at the outline stage, and from conversations certainly with some applicants, they welcome that because it gives a certainty as to what they're going to be required to do. But I think it's certainly something which can appropriately be addressed at the reserve matters stage. So we were certainly quite content to delete it. Okay. That was agreed, I think, with the appellant. Okay,
that's understood. So 18 disappears. We move on to 19. And you've just added the detail of which travel plan we're talking about, so there's hopefully no ambiguity. I think that was something I flagged on Friday. I didn't have anything else on that. Is that, off the top of my head, I can't remember, is that the version of the travel plan that appears in the court documents as C4.33? I'm putting everybody on the spot now.
Yeah, it is, yes. Okay. I mean, I think it may be just worth pointing out that that particular travel plan, I think, was based on the up to 71 dwelling scheme. So in that respect, it's slightly out of kilter with the proposal in front of you. There are one or two things which have probably been overtaken by events, because I think it refers to the bus service A5 in there. But I think we were agreed that the relevant measures and initiatives and targets for sort of modal shift are expressed in percentage terms and therefore remain relevant as part of the travel plan.
Okay, that's a helpful explanation. Thank you for that. Okay. Anything else on 19 before we move on? No. There's nothing on 20 or 21, and neither appear to have changed. 22 is a similar point to the earlier point about abbreviation, some of the abbreviation to NDSS. So I think that same point applies. 23. Oh, yeah, reference to building regs, and there's a note on this now. In response to the inspector's query, policy DM42 requires dwellings to meet an operational part of the building regulations. It's neater to refer to the standards rather than replicate.
Could I just confirm that actually that's meet an optional part of the building regulations, which I think is the relevant point. It's not an operational part. So it is effectively down to the local planning authority to express explicitly if it wants to actually achieve that.
So if it assists, the relevant SPD that's referred to is within your core documents, as core document B9. We have no objection to the reference to the M42 optional standard, and that's in compliance with the PPG about referring to the optional standards within the building regulations regime for the purposes of disabled access.
Okay, thank you. I'll just make a note of some of that. Okay, thank you. That takes us to 24. Turn the page. I think, again, looks like you've concluded that this goes to reserved matters and is to be omitted. Is that, have I understood that correctly? Okay, yeah. So you're suggesting that that's deleted. Okay, thank you. 25. Yeah, I queried whether or not this was a reserved matter point. It's still here, so presumably you both agree that it doesn't, and therefore it's necessary. Could somebody just talk me through that?
It's somewhat splitting hairs. We don't have any particular objection if it's dealt with at outline or reserved matter stage, sir, but with regards to the fact that there are landscaping components that are set out within the parameters plans that form part of the rationale for the case before you, it's felt that that may be pertinent to draw into the outline stage.
I think from our point of view, we agreed that point, and almost invariably, in my experience, those two conditions have worked almost as a suite of conditions with effectively what is condition 1, which requires the landscaping of the site. So in our view, there was a logic in retaining those as a sort of an operational group of conditions.
So you see it working with condition 1?
Yes.
Yeah, okay, I understand. Okay. I think that was it, although there's some change to 27. Could somebody talk me through what's changed in 27?
Yes, I think on reviewing that, we felt that there was a reference to sign off, and we felt that perhaps wasn't the clearest expression of what was meant by that, and might be open to confusion as to what was expected. So we've expressed that instead of sign off of mitigation measures by an ecological consultant, we've made it more explicit that it has to be written confirmation by the ecological consultant that the mitigation measures have been completed. And that written confirmation needs to be submitted to the local planning authority. And then the paragraph below that requires that the approved plan is fully implemented And rather than the slightly vague statement about adhered to over the operational phase of the development, we said it should be maintained at all times following confirmation of receipt by the local planning authority referred to in sub-point 5, which was that written confirmation that the mitigation measures had been completed.
Okay, thank you. I've read that, and just to be clear, the this ecological consultant may be instructed by whoever was seeking to discharge the condition, and that information would come to the council,
That's
local planning authority, to accept or reject.
Yes, that's correct.
Okay. Thank you for clarifying. Yeah, that's helpful, thank you. That's all I had on Appeal A. Is everybody happy for us to move on to Appeal B now? Yeah, okay, we'll do that then. Turn the page. Okay, there was nothing on condition 1, which was just the implementation commencement condition. Condition 2, there's a change, and I queried about implementation. I'm guessing this goes to that point. There's an additional sentence been added onto it, which reads, construction of a hard standing and works of landscape should be carried out in accordance with the approved details before the connection between the proposed residential development of a hard standing and associated works is open for use. Okay, so that attempts to go to the implementation point. Is there any ambiguity about what the residential development means, bearing in mind that doesn't form part and parcel of this planning application for Appeal B?
Yeah, I think that was something we looked at, and I'm just wondering whether that might appropriately actually refer to a specific reference number, i.e. the appeal reference number.
Okay.
So I don't think it's necessarily pertinent, but obviously Appeal B theoretically stands on its own 2 feet as a proposal before you, the likelihood of which it coming forward without the development to the south seems somewhat absurd. But you may wish to refer to before the connection is made to the land to the south, or some such alternative.
Okay, thank you for your views on that. We'll move on then. I didn't have anything on 3 or 4, and neither have changed. So unless anybody wants to talk about either of those, we'll move on to 5. So 5 reads, no development should take place until details of a proposed means of protecting privacy and living conditions of properties neighbouring the proposed path have been submitted to and approved by the local planning authority. And I think I was really wanting to get some clarity on what I was seeking to achieve, and I see a note has been added, so I shall read that. Note in response to inspector's query whether this is necessary. The path will introduce a significant number of pedestrians and cyclists passing close to the existing dwelling, which has exposed garden and windows of habitable rooms where this has not previously been the case. It will affect the living conditions of occupants. So, well, I don't think there's much that can be added to that. Is there anything that can be added to that?
No.
No.
So just to clarify our position, sir, we initially raised queries about this condition. There was some discussion in advance of conditions being drafted between the parties in relation to this. Our beginning position effectively was such that I believe this refers to the western boundary of Mrs. Edgar's property, where the hedgerow is maintained low and looks out over the track. And we discussed whether essentially no different to any other pedestrian path adjacent to a property, and it's within their gift to manage that boundary hedge as they saw fit. But I understand as part of discussions between that party and the local planning authority, that issue obviously had been raised, and so if it was felt necessary to make the scheme acceptable, we have no objection to facilitating some form of boundary treatment there if it's desirable.
Okay, thank you. Just something caught my eye. Just bear with me a moment. I think, strictly speaking, the wording says no development should take place until details of the proposed means of protecting the privacy and living conditions of properties neighbouring. Strictly speaking, it's not the properties, is it? It's the residents of the properties. So that might be something that needs tweaking. But I'll just flag that in. If anybody disagrees, I'm sure you'll let me know. That brings us to condition 6, which is similarly affected in the terms of the lighting condition. We talked about in respect to appeal A, and I see it's been similarly adjusted. Have I got that right?
Yeah, that's correct.
Okay. Well, we'll move on to what's listed as yes, we've still got this numbering issue. We go from 6 to 8. Is there an explanation for the mystery condition 7? Does it not exist? Does it exist?
Not that I can provide you with. No, I'm not sure. I looked at that last night and was trying to puzzle that out.
Okay. Well, it woke me up if nothing else, because I thought, well, goodness, I've lost a condition again. But it came back to me. Okay. So it looks like the condition, I'm going to call it condition 7, even though it's listed as 8. That's been rationalised in a similar manner to the appeal A scheme in terms of essentially bringing the two lists together. Have I got that right?
That's correct. Yes.
Okay. Well, thank you. I'll just take a moment to read that. Okay. Yeah, and it does continue over the page, doesn't it? The rest is as was. Okay. That's all the conditions that are suggested by the main parties. Was there anything else anybody wanted to say about conditions, and is there any review that some things that should be there isn't in there? No? Okay. All right. Well, on that basis, I think we can draw the roundtable session to a close. Thanks for everybody's contribution and participation. Can I just pick up the point from this morning I flagged regarding the site visit in terms of contact with the 4 parties who've requested that we visit them, please.
Thank you. Yes, we have successfully made contact, and I've shown all of the parties a list, and I've actually marked up the addresses for you on a map, and all of that's agreed. We've also got an agreed proposed route for you, which we'll ham round in a minute. In terms of the specific parties, you referred to a Miss Markovic-Buck, who I've been in touch with via email today, and would, yes, please, still like you to visit. As I say, I've got her address details for you, and I've indicated that you'll start the site visit around 2 o'clock, but obviously not given precise timings. The second name that we had was a Mr. Andrew Hunt, who lives on the Wiltons. Mr. Hunt is actually on holiday at the moment. Contact has been made with him, and he would be content for you to access the property by the rear gate. However, as what could be a more suitable alternative, Miss Stockham's property is next door and obviously has exactly the same viewpoint. So subject to the parties' agreement, the same views could be obtained from there in her presence.
Okay, that sounds fair enough. I can't imagine it will take very long to pop into Mr. Hunt's rear garden as well, so perhaps I can just do both and to,
Yeah.
you know, kill a couple of birds with one stone. Okay.
Lovely. Mrs. Edgar, we've obviously spoken to and is fully aware that you'll be attending her property.
Yeah.
And the fourth name that we had was Mrs. Whittam, who I've spoken to this afternoon on the telephone. Again, yes, she would still like you to attend, please, and have indicated that it's likely to be somewhere between 2 and 3 o'clock.
Okay.
She has no time constraints until 5 p.m, so I'd hope we were well done before then.
That's helpful, and if I've understood correctly, she's on the eastern side of Buttsbatch
Yes.
from the site. Okay.
Yeah.
Okay, and you've got
I've
you've
done
got
a
an
list
itinerary
and a
in
map.
mind.
Yep.
Okay, excellent. Okay, well we can pick up the details tomorrow once we know what time we're finishing and how long it will take us to get there and so on. That's really helpful. Thank you. And did you say there's for the off-site, or the other off-site, when I'm going to be covering matters alone, is there now an agreed map or something for me to refer to make sure I'm looking at all the right things?
So
and all the things.
we have a route proposed for the close-up views. I understand that you indicated you'd visited the range of viewpoints from the various parties in advance of the inquiry opening in any case. So we've only directed towards the local views directly to the south within the site, going along the Appeal B route and then coming up and around to the public right-of-way to the west of the appeal site.
Okay, and is that available? Is there a map?
Yes, sir. I don't know if...
Excellent.
The
looks
local
like
authority
a
have
map.
it to hand, sir.
Yeah, I mean, it can wait till tomorrow, but I'd just rather have it now if it is available. That would be great.
I would only just highlight, I'm not 100% sure if Rule 6 party have confirmed that as
Okay.
well.
Well, let's not jump the gun then. If you can have that
I'll
conversation.
hand them round to the parties tonight, and then perhaps we can hand you one bundle of, as I say, the addresses and the agreed
Please.
list in the morning.
That would be helpful. Thank you. Regarding, we've got these 4 parties who've asked for me to view from their property, and well, it's kind of 4.5 now with your property as well. Is anybody aware of any others that might have sort of slipped through the net? No? Okay. Not that I'm inviting anymore, but I thought I'd just ask, just to be on the safe side. Okay, is there anything else that is outstanding that can't wait until tomorrow? No? We've just got closings remaining. In terms of, obviously there's time for things to change and instructions can change, but just to help me with timings for the site visit, is there a prospect of any party making an application for an award of costs? No? Okay. Well, I recognise that can change, but that's just helpful. Okay. On that basis, we'll adjourn now. Gosh, almost bang on 5, and we'll resume again tomorrow here at 9:30. Thank you all. We're adjourned now.